Miss Allen, you can turn your camera off.
Whoever just mentioned that, I would note that there's two Mrs. Allens.
Right, there's a bunny rabbit Allen and
The bunny rabbit's the one that's moving.
okay. I mean, it doesn't bother me. It's the noise, but it's muted, so we're good. Okay, Ms. Rivers, can you hear us?
Yes, I can.
Great, we're gonna get started. Thank you for joining us. This is 00SC09016, State versus Singleton. We are on round 3 or 4 of hearings in connection with this motion for new trial. Mr. Hort is here on behalf of Mr. Singleton. Mr. Armstrong is here for the state, and Mr. Singleton is appearing virtually. Mr. Singleton, give us a wave if you can hear us. There we go, got the wave. As always, Mr. Singleton, if you've got a question or a concern, wave your hands. We'll pause what we're doing. They can turn your microphone on and we'll hear from you. And it may well be that Mr. Hort's calling you as a witness today. I don't know what is planned for the session, but unless questions are directed towards you, we'll leave your microphone on mute. But if you've got a question or a concern, just start moving around sort of like the bunny rabbit, and I'll see you and we'll pause, okay? Thank you. Mr. Hort, good morning.
Good morning.
Give me, please, an outline of where you think we're going. We're not gonna have Mr. Waters here, and I'm interested in understanding what changed. You may not know, other than that he changed his answer from yes to no. We have a witness here, and just for planning purposes, I'm presiding today, so we may from time to time have to pause if someone comes in to work through a little something, but otherwise I have some time to see how much we can get through. I just wasn't sure what remained from your presentation before we pivot to the state to see if they're presenting anything.
Yes, sir. The plan today is to begin with the second chair, Susan Wardell, who is sitting in the witness seat. And then after that, I would be calling our investigator, Tony League. And then last would be Mr. Singleton.
Okay. Hopefully we can get through all that today. Let me spotlight the witness. There we go. And we'll spotlight the podium and we will add Mr. Singleton. All right. Mr. Armstrong, anything we need to cover procedurally from the state?
Not that I'm aware of.
Okay. We will break for lunch. I have to shut down for presiding, so hold on a second. Something just happened.
I just unmute. Was I wrong?
Yeah.
Oh, sorry.
It's okay. We will break for lunch. We'll find a natural time to do that. It won't be mid-sentence or anything like that. But then we can just come back after the lunch break. But my team has been on all day for the presiding, and I have to shut that down for an hour so they can get a break. But there's not a magic time when we do that. All right? When you're ready.
Thank you. The defense then will call Susan Wardell to the stand.
All right, Ms. Wardell, you're welcome to remain seated. If you just raise your right hand, Deputy Gordon will swear you in.
You swear affirm the testimony you will give the truth, the whole truth, nothing but the truth. Go ahead.
I do.
State and spell your name for the record.
Susan Brown Wardell. SUSAN BROWN WARDELL.
Ms. Wardell, let's start with a little background. If you could give us some background information about yourself.
I am 78 years old. I'm retired from practicing law. I went to Duke University and got a BA, and then I got, in years later, when I was about 40, I got a master's degree in social work and clinical licensure from UGA. I then went to law school at Georgia State University and finished in 3 years. While I was in law school, I interned at the Georgia Public Defender Standards Council, where I worked on mental health advocacy work with the NGRI patients who were at Central State Hospital who have been incarcerated but acquitted for not guilty by reason of insanity. After I graduated, I started working full-time in the mental health advocacy division, training lawyers to recognize incompetence and insanity in their clients. And we did some work with the courts as well. And we also tried to get the people out of the hospitals when it was feasible. While I was there, I worked some with the felony trial division of the Georgia Public Defender Standards Council on some of their criminal cases and some of the death cases at the Capitol Defender. We were all in the same building together. After 3 years in mental health advocacy, the state of Georgia opened conflict defender offices around the state. And I think the first one was in Fulton County. And so Paul Keir was the director of that, and I went to work for him. I had worked with him on some of his cases. And so he thought that I would be a good resource for the attorneys in the office. We had about 16 or 18 attorneys. And I had training in a lot of mental health areas that came up with the clients. So if they had a mentally ill client or a battered woman or a case like that, they would come to me and sometimes give me the case, sometimes ask them to help with it. And also we had a lot of SB 440 cases, which were the juveniles charged with adult crimes for several major felonies. And those kids, I hate to call them kids, but they were kids, their cases were lodged in Superior Court. And they would have a hearing with a magistrate judge to determine whether or not they were transferable to juvenile court. However, murder cases were not, and party to the crime of murder were not transferable. So those remained in Superior Court. I had a lot of those cases to work on with my trial partner, who was Gary Gishard.
What type of work would you be doing then with the SB 440 cases?
Well, you have to spend a lot of time with these young people because they have a hard time sort of understanding where they are and what's going on. Plus, they have a lot of issues. One of the big ones is that their home lives aren't anything they can do anything about. They can't run away. They'd be returned to their parents. So they're stuck in the situation they're in, whether there's a lot of abuse, whether there's any home training, or whether they're just on their own. And a lot of these kids were just on their own. Some of them didn't even have a place to sleep. So I had to spend a lot of time with them, learning about them as well and their abilities, as well as facts of the case and how they got to be where they are.
What about so far as the possibility of any type of plea agreement? Were you involved in that with the SB 440s?
Quite a bit. It took a long time for me to work with the prosecutor and often the judge pre-trying a case when it was a very serious case with a very seriously disturbed defendant. So I did a lot of negotiating and talking about, the vagaries in the child's behavior and how some of it would just be so impulsive that there wasn't any intent. They just would act. And that doesn't go very far, because if it's a murder, and this child is being treated as an adult in adult court, the standards for judging them are pretty much adult standards. And it wasn't until after I had left and our office was closed in 2005, that the Supreme Court ever recognized a difference and decided in Roper v. Simmons that death penalty was unconstitutional for juveniles because of their particular characteristics.
So again, we're talking about the year late 90s, early 2000, and how it was in Georgia then with
Well,
juveniles and murder.
Then I was not permitted to testify as an expert in juvenile behavior because it wasn't considered beyond the ken of the average juror to understand how adolescents are different than adults. And it would have been considered bolstering, I suppose, but it wasn't admissible. So I was able to use that only in negotiation.
Did you have any success with the negotiation?
Yes, often. I managed to get a case where they backloaded the sentence so the young man could be on probation and go to school. And I've forgotten what all the parts of it were, but he had a part-time job, and it was Judge Manis, and she said if he didn't reoffend in, I think it was 5 years, that she would dismiss the case. And she did.
Was that a murder case?
You know, I can't remember.
Did you have any success in murder cases, the SB 440s?
Only to the extent that I did get one reduced to 10 years, and it was a young man who'd been badly abused by his stepfather, and he killed his stepfather.
Was that the one you were telling me about with Paul Howard, or is that a different one?
No, that was a different one. I did negotiate with Paul Howard a number of times,
Which all due respect,
especially on
is-
death cases. Yes.
all due respect, that's quite an accomplishment there.
Well, we had a pretty good relationship.
I think you also mentioned you had some success with the SB 440s with Ms. Ross.
Yes. No, I didn't have an SB 440 case with Miss Ross until Mr. Singleton was a defendant, but I had not worked on his case.
Okay. But I mean, I remember you telling me that you did work out a negotiation with her and some
I
other
did
case.
on a death penalty case, and the woman ended up with 40 years.
Okay. So you did quite a bit of negotiations with death penalty cases, murder cases, SB 440s. That was kind of your role in the department.
That was something I was better at than some others because I had the extra training with my master's degree in social work.
Now, what about after leaving the department in 2005? Tell us a little bit about what you did then.
Well, the legislature decided that we didn't need a conflicts office anymore, so they abolished the conflicts offices in Georgia. And by then, we had 6 social workers on staff who were working with the mentally ill and running a mental health court. And we had won an award for that. And yet the legislature decided we didn't need the office or the social workers. So they abolished our office. And I went into private practice as a death penalty mitigation specialist. And in Georgia, they have a Georgia capital defender, which takes the indigent criminal defendants in death penalty cases. But Alabama did not have that. So I lived in Alabama with my family, but I lived in Atlanta with my family, but I drove to Alabama and I got an apartment over there and I worked on death penalty cases in Alabama for the next 12 years.
Did that ever include testifying as an expert in Alabama?
Oh, yes, several times.
In what area?
In battered women's cases, in competence to stand trial, not guilty by reason of insanity, what mitigation work is, and in sexual abuse cases, such as child sex abuse accommodation syndrome.
Did any of that include juvenile behavior?
It did. After Miller v. Alabama came out in 2012, I had about 5 Miller cases all of a sudden. And that Miller said that life without parole was inappropriate for juveniles. And there were a lot of life without parole juveniles in Alabama. So I was given these cases And I testified as an expert about the characteristics of juveniles that are usually different than those of adults.
I have a note here that you handled over 100 death penalty cases as a mitigation expert. Is that correct?
That's true. I did 2 a year in Fulton County. And then when I got to Alabama, I did the balance of them. And of course, they didn't all go to trial. Most of them were negotiated to life without or life. But I was assigned, or the courts, the attorneys chose me to work on their case, and the courts would order me to be paid. So that's how it worked.
And did that then include adult and juvenile cases?
Well, by then they weren't doing death penalty against juveniles in Alabama. So it was adults.
Now, let's go back and talk about the Leslie timeframe. Tell us about what was your caseload like? What were you doing then?
Well, I had started a mental health court in Fulton County with my social workers and a volunteer judge and a volunteer prosecutor and a volunteer defense attorney. And I was supervising those social workers. And I also had cases of my own, which were mostly abuse cases.
Who was the judge who volunteered to do the mental health court?
I'm trying to remember her name. I believe she does family court now. I'm not sure. It's a young woman with long brown hair.
Okay.
Sorry, I'm 78. It's
That's
been a
okay.
while.
You and I have the privilege of being the oldest people here. I want to say the most smartest ones here, but I won't say that.
My memory's not so great.
And in fact, that was an issue initially in this case. You didn't even recall being part of the Singleton trial or case.
I wasn't. And I almost need to explain. Gary Gashard was assigned to work with me, and we were supposed to be the major case division. He had a good reputation in Chicago, where he was a public defender, and he had done a lot of trainings, I think at NLADA conferences. And he was hired by Mike Mears for the Capitol Defender's Office in Atlanta. After he worked there for a while, Mike Mears let him go. I'm not sure why, but Paul Keir hired him and hired me to work with him. And Gary was supposed to teach me trial skills because I didn't have any, and I still don't.
The idea is he would be the first chair and you would be
I would
often
be
his
second chair, yes, and he was supposed to be training me. And I did work on most of the SB 440 cases that came in because it was presumed that a juvenile has issues, especially a juvenile that's committed murder. And so I was almost always included on those cases, but I was not included on Leslie's case for some reason. And I don't know why that is. I do remember the name on the file folder and saying to Gary, what are you doing with this case? Because we were a team, and he kept some cases for himself when he said they weren't complex and he could handle them himself. And that was one that he said wasn't complex and he could handle it for himself. And so when it came time for trial, he said, oh, I'm trying the Singleton case on Monday. Would you sit and take notes for me? And that's how I was listed as second chair. I wasn't involved in the case. I had not met Leslie. I copied Gary's file, but it didn't have notes about the client, which, I mean, the way I learned the most about a case is from the client, and it wasn't there. So I did what I could. But Gary didn't like to have me correct him. I remember one time telling him that in his closing argument, he really owed it to the client to raise the burden of proof. And he got quite annoyed. He didn't like to be corrected, and especially by somebody with so much less experience than he had, because I was a little bit older than he was. He was in his 40s.
But then you really played no active role in Leslie Singleton's case?
No, I took I took notes of the witnesses so that he could do his closing argument. But I had read the file and I knew, who the detectives were and that sort of thing, and who the defendants were, but I hadn't worked on the case. I was just there.
What was his normal, how many cases would he have at any specific time? What was his?
Well,
Can you tell us?
between us, we each had about 20 or 25 cases, plus 2 death cases at a time. And that was the contract with Fulton County for the conflict office. And so we had, the other attorneys had hundreds of cases sometimes. And we were supposed to be spending extra time on our cases. And I did, but he didn't like to go to the jail. So he didn't spend much time with his clients. So his clients, ended up feeling very anxious and not knowing what was going on in their cases. And I guess if they were in court, he would always speak to them, but I don't know. I couldn't, he wasn't my responsibility. I was his, sort of.
And like you said, at least at some point in his career, he was a very good trial attorney.
Yes.
Did you see issues that then came up with him?
He developed narcolepsy and would fall asleep when we were in court. And I don't know if he fell asleep when he was at his desk or not, but I know he fell asleep in court. Sometimes we were waiting for, our turn, he would fall asleep, and sometimes, and he was one time fell asleep while the prosecutor was giving his closing argument. And I remember Judge Downs called him up to the stand and said, "Mr. Gashard, you're falling asleep." And, I was nudging him and doing everything I could. He didn't tell me he had narcolepsy. He told our investigator, and the investigator told me, and he had been prescribed, I think, Ritalin to stay awake, and he didn't want to take it.
Is this something that necessarily would have been observable by you or by Mr. Singleton sitting at the table with
Oh,
him?
surely, yes.
You could tell, is he asleep or is he thinking?
Well, a lot of times he'd say he was thinking, but he was asleep.
Okay. And
I'm sorry to interrupt, but are you saying, Ms. Wardell, I just want to make sure I'm separating out things you observed Mr. Gashard do during the many months you worked with him versus what you observed during Mr. Singleton's trial? Are you saying that you can recall times when you felt that Mr. Gashard was asleep during Mr. Singleton's trial? Or are you saying, I know that happened, so it probably happened in the Singleton case, but I don't know?
I would say it probably happened during the Singleton case because it happened so much.
Okay.
But I can't say for certain because it was a long time ago.
Got it.
And I guess relying on your knowledge or experience, is this something that a juvenile would have noticed?
Oh, sure. I think that would be terrifying.
But I mean, certainly it's not something a juvenile would expect from their lawyer.
No.
So would the juvenile then realize that the person is sleeping, or would this be, I don't know what's going on?
I don't know what he would think, but it wouldn't be good.
Now, what was your work relationship with Carl Greenberg?
Carl Greenberg had an office next to me, and he was the appellate attorney for our office. And when I think about it, lately I realized maybe that wasn't a good fit, because he was going to have to say that people that he knew and liked were ineffective. As far as I'm concerned, if I were ineffective, I'd just as soon admit it if it would help my client.
So Mr. Greenberg was the appellate lawyer, not with GPDC, but actually for the conflict defense.
Yes. Which is a conflict.
Seems like a conflict.
Yes,
for the
it
conflict
does,
defendant.
doesn't it? Yeah.
Okay.
And is it true then that he handled all of the appeals?
He did all the appeals for our office.
And your office physically was right next to his?
Right next to his.
What can you tell us? What did you see? What did you notice?
Well, before I was going to be working with him, I asked a woman who had worked with him at the DA's office, because he was in the DA's office for about I don't know exactly how long, many years. And he was let go.
Objection, hearsay.
I think what she's gonna go into is his reputation,
And she knows about his reputation.
from what she's been told, from what she's observed.
Working with him.
I'm sorry.
From working with him.
Okay, make sure you don't answer questions that I'm asking Mr. Hort, but insofar as you want to cabin this to what Ms. Wardell observed, Mr. Greenberg do, as opposed to what other people told him Mr. Greenberg did or didn't do, then I don't think you run afoul of a hearsay objection. There may be exceptions to it, but short of an exception to the hearsay, I think now that that objection's been lodged, it would need to be what Ms. Wardell experienced because of her interactions with Mr. Greenberg.
Let's start there then. What can you tell us?
He was very lazy. He did not do his job. He got lots of letters from clients wondering what happened to their hearing for their new trial. I never saw him looking at a transcript once in 7 years that we worked together. He often would go to the movies in the afternoons, and I'd be coming back from the courthouse to the office, and he'd be coming back to the office from the movies. And I was really distressed about that because I had clients who were wondering what happened to their motions and their hearings. And he spent a lot of time gossiping and interacting with the other attorneys in the office.
And did you at some point actually look in to see how many cases he actually was doing?
I did.
What did you find
When
out?
our office was going to be disbanded, and I had 2 clients who were quite upset that their hearings hadn't happened, I decided to see what he had done, and I investigated how many cases he had done in the DA's office, and it was 17 a year, and how many he had done in our office, and it was 17 in 7 years.
And obviously there would have been many more than that would have come to him.
Oh, yes. And I said something to him about it, and he was embarrassed, and he suddenly started working hard on the 2 cases that I brought up.
Now, after your office was closed, do you know where he went?
I'm not certain. I think he was with the Georgia Public Defender Standards Council. And that's because he was still working.
So your office was closed December 31st, 2004.
Yes.
Did he then, do you know, if you know, did he keep some of his cases?
Yes.
You know why that would have happened?
I don't.
Okay, let's try to talk a little bit more specifically about the Singleton case. What, if anything, can you tell us about Mr. Singleton's efforts to pursue his appeal to get this thing going?
It's my understanding.
Objection, speculation.
Well, what can you tell us about juveniles then and appeals?
Objection, is this expert testimony about generally juveniles and appeal?
Why don't you rephrase your question?
What can you tell us so far as juvenile behavior as you go to the appellate stage?
Well, they really
Objection.
don't.
Don't answer yet. Tell me what you're trying to explore here, how it would be relevant here, because as I'm understanding your question, it would be asking Ms. Wardell, based on her interactions with former clients who had been found guilty, so convicted, and now we're in this phase of what's happening next. Is there a motion for a new trial? Is there an appeal, et cetera?
And discussing that as it applies to juveniles. The point that I was trying to bring out is that as juveniles, they didn't know what to do, who to write the letter to. Do you send it just to the attorney because he's your attorney? Do you send it to the state? Do you send it to the judge? And that's just what I was going to bring out, is to that juvenile behavior at that aspect.
Okay, so if Mr. Armstrong, if Mr. Hort is limiting the inquiry to Ms. Wardell's experience in interacting with juvenile clients post-conviction, what's your concern?
My concern is that it is a generalized question. He is talked to her as though she is an expert earlier in her testimony. And also, I'm not clear on what the relevance of it is, because I'm not saying that we should dismiss the motion for new trial because Singleton didn't do something else in the period of time. So I don't understand the relevance, and I also don't understand the relevance of this individual's opinion about how juveniles generally consider appeals.
Okay, I find it relevant, based on other conversations we've had in court about issues, some of which I've raised. But if you could target the question, so it's Ms. Wardell talking about her experience with her clients or former clients, post-conviction.
With that instruction, what can you tell us?
That my clients who didn't get their motion for a new trial hearing, they would write to me and say, I don't know what to do. What am I supposed to do? And we got letters like that pretty often. As far as a client having the wherewithal to go to a judge, that would be very unusual. They just didn't know where to go.
Now, back to again, Mr. Singleton's case specifically, were you aware of the Butts County case?
Yes,
With Mr. Gishard?
Can you
yes,
spell whatever that was?
The Butts,
Oh, Butts County.
yes.
Okay, I just want to make sure the record, I thought that was someone's name, Watsconi. I didn't know that. So Butts County, got it.
We're in Georgia.
We are in Georgia.
The Butts County case.
And
Were you
that
aware
was-
of that?
yes, I am Gary Gishard.
Your Honor, I'm gonna object unless there's a foundation for personal knowledge, because what's happened before is that the defense has presented a null pros. And so what is this person's basis of knowledge about what happened in Butts County?
That's fine. I thought that's what she was saying, but
So let's lay a foundation for how Ms. Wardell would know whatever happened in Butts County, not with her case, but someone else's case.
so again, we're talking about Gary Gishard's Butts County case.
Right.
How is it that you know anything about that you're able to testify here today?
Well, I was aware of it because he told me. And he had a client.
Okay, so don't go any further. So the origin will be Gary Gishard told her. Your objection?
My objection is hearsay and relevance.
Okay. Sounds like hearsay. I think I see the relevance, but you'll need to ask something different.
Okay. So Mr. Gishard did talk to you about the Butts County case. Do you know personally whether I'm going to use the initials FCCD, whether the department knew about it?
Yes, they did. The director knew about it and he spoke with me about it.
The director, meaning the director of GPDC?
The director of the Fulton County Conflict Defender.
Okay.
That was-
Your office.
Yes,
Mr.
my boss,
Keir?
Gary's boss, Paul Keir.
How do you spell his last name?
Keihir.
And what about attorneys, judges?
It was well known.
Did his caseload change at all post Butts County?
There was a distinct drop in the level of cases that Gary was handling. After that, there were some very simple cases.
But again, he still was the major trial lawyer for the FCCD.
Yes, and other attorneys handled some of the other more high-profile cases.
Do you know whether your office was aware of the narcolepsy?
I'm not certain how many people were aware of that, but I know I was and the investigator was, and I'm not sure if the director knew. I did not tell him, and I probably should have.
Let's talk about.
Judges were aware.
Let's talk about the investigator for a moment. So there wasn't one investigator for the whole department or each
No,
attorney?
we had 3 investigators.
Okay.
But we had one that Gary worked with the most.
Now, what was the connection between him and Gary? What the relationship?
They were friends.
Okay. To your knowledge, did that investigator ever do anything in the Singleton case?
Not that I could see.
For example, and the record will so reflect, he did not testify at the trial,
Not that I recall.
okay? And you never remember talking with him either by himself or with Mr. Gishard.
No, and I never saw a report.
So how many years did you work with Mr. Gishard?
7,
Okay.
closely at first, and then mostly independently toward the end.
And I believe you said, I'm not sure if today or to me, that he did have an excellent reputation as in cross-examination.
He did when he was hired.
What were the words you used to describe that?
I was told that by the director who hired him.
And do you remember what the description was? I don't want to put words in your mouth.
He said he was a real whiz.
Now, you have looked at the amended motion for new trial. You're aware of many of the issues.
Yes,
Would that whiz have done some cross-examination?
Objection, Your Honor, asking this person to opine as to the amended motion.
Your Honor, a person can opine without being an expert. And she's also opining as the second chair, who it was there and talking about issues so far as cross-examination.
Okay, why don't you ask your full question? Please don't answer it, Ms. Wardell, till I've heard the full question. Mr. Armstrong buzzed in a little early, probably correctly. I wasn't quite sure where the question was going to end. I was taken more by you referring to him as Wiz, but there's no jury in here. So, Mr. Gishard, and what was your question?
I could instruct her to use the word wizard if that would be preferable.
Yeah.
You're familiar, one of the issues is regards to the firearms ballistics, that issue. Are you familiar? That's one of our issues.
yes,
Okay. And you understand that there were a number of witnesses that Mr. Gishard did not even cross-examine.
yes.
Does that fit with your knowledge of the case, his description as this wizard? What can you tell us in that regards?
Objection, he's asking her to comment on whether she thought Gishard performed well.
Right, so you're in a tricky space here, because it wouldn't be a lay opinion evaluating whether there was deficient, sufficient, inefficient performance from co-counsel. If you want to explore specific things that weren't done or were done that surprised her, should she have that level of recollection, then you can certainly do that. But I think writ large, the sense of that was a deficient thing to not do this or that is problematic. That's, I think, the ultimate issue that we're working through. And you also have this funny inversion in place where the trial mentor is now being critiqued by the trial mentee. So I don't know how you want to move forward with that.
But with respect, I would point out, first of all, Mr. Gishard has passed away, so I can't ask him that question.
We all know that.
Second, Ms. Wardell was the second chair, so as such, she was there.
Mhm.
And third, she is an attorney. And yes, maybe back then he was the mentor and she was the mentee, but that was 23 years ago. She now has extensive experience that she has described in detail. So I would submit that with his passing, with her being the second chair, with her being an attorney, she can offer that opinion as to whether that was ineffective or effective assistance of counsel.
So here's what I'll let you do, and then we're going to pause for a second. I have to bless the indictments that were just brought in. More business for everyone, potentially. I will allow you to ask Ms. Wardell if she recalls particular things that surprised her about what did or didn't happen in terms of things that were done, but not, did you find that to be effective assistance or ineffective assistance? That's how I'm going to split that baby, but let me look at, is that clear enough what I described?
Yes, and I think
I'll just say, don't ask it that way, ask it a different way.
I'll then probably try to do it with more specific instead of just asking this broad question.
I think that's what you'll need to do.
Okay.
All right, give me 1 second. leave you hanging here. I'm just making sure everything got signed. I was just at a training and some judge said, I never used to look at them, and there were 3 indictments that hadn't gotten signed. So I figured we'll save everyone the hassle. Yeah, that's too many pages for me to turn. I don't want, you'll be here all day. I'll at least cover the first part, let you guys get to the other stuff. When they have 2 different signatures, that just means someone might have been on break. You're allowed to leave the room, and so the deputy foreperson or whomever. Okay. So, all right, so I'll keep this. I will sign this. All right, I'm sure I will see you again this week. All right, thank you.
Never been present for that.
Hmm?
Never been present for that.
Now you see the drama and intrigue of it. This is an improvement, the fact that there is a list kept so that when we get the inevitable 5 years later, there's no proof that it was presented. You guys keep this spreadsheet. Good work.
Nothing will satisfy them.
Nope, or they'll still file it, but at least then you can attach something like this. All right. We are back to Mr. Singleton's motion for new trial. Ms. Wardell is still on the stand, and Mr. Hort had some bonus time to refine his questions about Ms. Wardell's recollection of what happened and didn't happen at Mr. Singleton's trial.
And Ms. Wardell, we'll get back to that question later. You had mentioned before that, if I understood correctly, the norm working with Gary would be that there would be some trial prep involving him and you.
Always.
Did that happen in the Singleton case?
No, I couldn't believe that I hadn't been consulted on it because it was a juvenile and I was almost always involved in those cases.
Did you talk to Gary about working on that case?
I didn't even realize it was an SB 440 case.
So you would not have then been at the SB 440 hearing?
No. Those were given to me by different attorneys in the office or by Gary. And I don't know what happened.
Speaking of that, do you know how that works? How does a case get assigned to a specific attorney? I know how it gets assigned to the department because it's a conflict, but who makes the determination as to whether Gary gets it or some other attorney in your department?
If they were an SB 440 case and a murder case, then they went to Gary and me, but primarily Gary.
And I believe you said that you do remember seeing the file folder and reading through it.
Oh, yes.
Did you talk to him then about that?
Yes.
What can you tell us?
He was angry at Leslie. And I think he,
Mr. Gashard was angry at his client.
yes.
Okay.
And there was a note in the file to that effect.
Do you know why he was angry at Mr. Singleton?
I think that there was, in fact, I know that Mr. Singleton didn't tell him the truth at first about who was with him at the event. And then he found out the truth at a later time and he came back and was very angry.
At that point, did then things seem to change so far as representing Mr. Singleton?
He obviously didn't work very hard on the case. And that's what I remember, that Leslie's name would come up and the case was sort of always there. And I asked him, what are you doing on this case? And he wasn't doing much, but at the time, I didn't realize why.
Did Mr. Gashard ever have any strategy meetings with Leslie and you?
No.
Did he ask you to do anything in this case?
Read through the file and come to court and take notes for him.
I believe you said like a paralegal.
Like a paralegal.
So we talked about Mr. Gishard getting angry or mad at Leslie. Did this also happen in the Michael Lewis case?
Objection, Your Honor, relevance.
Don't answer the question. I don't know what case that is. How would that, this is sort of the 404B that I don't think we're getting into. I'd ask if you could focus more on where you were headed, which is, did you see this happen in the trial? Did this not happen? No trial prep sessions with Ms. Wardell. She was excluded from those if they happened at all. No trial strategy sessions with Ms. Wardell. We've learned that there was some tension between lawyer and client because lawyer felt client wasn't candid. And Ms. Wardell's perspective that caused Mr. Gishard to be even more disengaged. Then we pivoted to some other case. I'd ask that we stay on the Singleton case.
As an attorney, what would you have done or should an attorney do if you have that type of conflict?
Transfer the case to somebody else.
When you say conflict, you're referring to this perceived tension between Mr. Gishard and Mr. Singleton, supposedly because Mr. Singleton wasn't candid the first time through or at some point about what happened.
Except I would not call it perceived. It was very real.
Well, you might know that because you've spoken with Mr. Singleton. I don't know that. I know it. I mean, part of your issue here, and I appreciate Mr. Gishard can't be here, is we're getting this through the lens of a third party, not Gishard and Singleton. We'll have that. Ultimately, we'll have one half of that dyad when Mr. Singleton testifies.
It's not just me knowing it, she knows it.
Okay.
Yeah.
All right.
Your Honor, you'd actually asked a clarifying question, I don't think. The question was the conflict that you're referring to, the tension between them. And then there was just a discussion about whether those real, right? Now that I'm saying it out loud, but.
Yeah. Okay. But that's the conflict he was referring to, not a Mr. Gishard had represented Waters in a different case. It was conflict as in, we might think of it, you and I are having a conflict, we're disagreeing, you aren't right now. And so Ms. Wardell gave her answer.
Thankfully, I can tell when you are angry, and I don't know that I've ever seen you angry. While you were taking notes during the trial, did you ever pass those notes to Gary?
Yes,
And did he then follow through with direct or cross exam based on those notes?
no. He didn't like to be corrected.
Were there any notes in the file that you made about not performing adequately?
I just used sticky notes. I don't know what became of them.
So we talked a little bit about Mr. Gishard getting angry with Leslie once he found out that about protecting his friends. What can you tell us so far as is that expected juvenile behavior?
Yes,
What can you tell us?
Objection, Your Honor, is she being tendered as an expert to testify about these things? I'm very confused.
I don't think you're confused, but you're right that we seem to be dipping in and out of expert waters. I don't know that you need to tender Ms. Wardell as an expert if you are basing your questions and want to preface them based on your experience and your interaction with countless juvenile clients, then maybe she'd be in a position to answer those.
Let's do it that way, based on your experience.
based on my experience, yes, he would want to protect his friends because he had no family. His mother was in jail. His father was absent. He was taking care of himself. And he had his peers. And one of the peers was 4 years older than he was.
Objection, Your Honor, she's testifying facts now that are within her personal knowledge. If it's just to inform her decision, that's one thing, but Mr. Hort has tried to get that information to other witnesses.
When you say one of his peers, are you referring to a co-defendant in
Yes.
the case about
Yes.
which you would know?
Yes,
And I would know because it's in the record of the trial.
yes,
This isn't a friend from
No.
outside the circle of
no,
people who were implicated in the murder.
no.
Okay, all right.
Overruled,
Overrule.
may continue.
Peers are really important to juveniles because they're looking for acceptance and they're looking for role models. And Mike Waters was a role model to Leslie, and he was the leader. And the worst thing you can do is snitch on your friends.
Stop for a second.
Find that he was the leader.
He Waters.
That Waters was the leader, that is an opinion based on evidence. And I don't believe that she is authorized to make an opinion like that. That is an opinion about the facts of the case, and
I got it. So I guess I just need to make sure I know. May I pause for 1 minute? Ms. Griggs, did you let Deputy Gordon know whatever it is you need?
I called Chambers, Judge, I apologize.
No.
I learned that you were residing, and I have a very interesting issue that I'm probably sure neither one of us is really gonna know about, but I'm just
Okay, as long as you
floating
should.
around, yeah,
Great.
yeah, talk to people in the back about what I'm.
Okay, good. We'll connect.
Okay,
All right, I'm sorry. I think we'll be able to progress more efficiently through Ms. Wardell's testimony if you can preface your questions with, in this other case that's not properly before us, then there can be an objection. Or in this case, from the trial, were you able to determine, et cetera, because that's not an expert opinion. I'm not as well versed in the record from the trial, but it sounds like from the record in the trial, one could discern a leadership role and a follower role, maybe partly extrapolating from the 4-year age gap or testimony or who knows what. So I don't think we're getting into expert space here by having Ms. Wardell talk about what she learned from reviewing and participating in the trial.
So from this trial, but then also I expect that Mr. Singleton will testify that Mr. Waters was the leader. Can you then answer the question?
Well, the peer relationship is so important to juveniles because that's especially a young person in a situation like Leslie's, because that's pretty much all he had. And his older sister was gone from the home and he had his mother in jail. And the friends on the street are going to be very, very important. That's like family to them. So to snitch on his friends was the worst thing he could have done. And he was determined not to snitch on his friends. So he made up 2 people who actually were not involved in the case. And that's what he lied about to Gary and the police.
You'd mentioned earlier that the courts back in late 90s, early 2000 didn't much like having juvenile experts. Is that correct?
Well, it's a question of whether or not juvenile behavior is beyond the ken of the average juror. And at the time, it wasn't common to have an expert on juvenile behavior in Superior Court. That's what they use in juvenile court. And that's the purpose of juvenile court, is to attend to children or young teenagers. And these are young teenagers, but it wasn't something that we could have gotten in, nor would probably Judge Downs have allowed it. I don't know. We didn't try that.
Would a juvenile behavior expert, though, have been helpful in this case?
Well, I probably now it would be permitted. I'm not certain.
But the
I think
question
it'd be
wasn't,
helpful.
would it have been allowed, or would it have been helpful? If you were able to convince that judge to let it in, is it something that would have been useful?
I think so, yes.
For example, what you just testified to so far as lying to the police to protect his friends. Wouldn't a juvenile behavior expert help explain what you just said to the
Yes.
jury?
Yes.
And I would assume every parent kind of gets that.
That's the presumption, yeah.
Were you aware that Gashard had encouraged Mr. Singleton to lie at the trial?
No,
Did that ever come up?
no.
Yeah, and I'm ready to start a kind of a new line of question. I don't know when you wanted to take that break or if you want me to keep going.
The lunch break?
Yeah.
Oh, let's go. Well, how long do you envision your direct going?
Probably till 1 o'clock.
Because you got another hour. Okay. We could do that. Then I can, I've got a couple of presiding matters here. So why don't we do, Ms. Wardell, are you able to stick around for a bit?
I could do whatever needs to be done.
Okay, I appreciate that. Do you think we'll finish today, or it's hard to know? With you, it's hard to know. Well, we'll finish with Ms. Wardell for sure. So we've got that goal, and then that leaves your investigator and Mr. Singleton. And so we'll get as far as we can with your investigator.
I don't think the investigator would take anywhere near as long as Ms. Wardell.
Okay.
Obviously, Mr. Singleton probably will take about as much time as Ms. Wardell.
Okay, I'm not rushing anyone, and if we need to set up another session, we'll do that. But I want to make sure we don't need to have Ms. Wardell come back on a different day.
Thank you.
All right, Mr. Armstrong, you okay if we do the lunch break now?
No objection.
You blocked out your afternoon?
I have nothing other than a brief due by midnight.
Well, there you go. I'll give you your evening. Then why don't we break for an hour? I was going to suggest we do it shorter than that, but I have to let the staff have since they're on for presiding. So let's try to start at 1 o'clock sharp. It's a little less than an hour, but we'll resume where we were. More questions for Ms. Wardell from Mr. Hort, and then we'll see if there's any cross-examination, and we'll move on. How are we doing on the GDC side? How long do we have Mr. Singleton available to us?
It should be a problem for them to log back on, Your Honor, at 1 o'clock.
Okay, well, why don't we do that? We'll see him at 1, and then obviously, if they say we have to stop at 4 because of roll call or this or that, we're beholden to them. We're very grateful to the support they're providing. All right, then we'll pause until 1. We will resume at that point. Thank you.
Thank you.
Thank you, Judge.
Mr. Armstrong, different case. The original motion for new trial was found and uploaded, so it's in the docket now.
Thank you very much.
Yeah, thank you, Ms. Hansberry, but I started going through it, like, I can't find it. She found it and had it scanned in. So that is now viewable without having to touch old papers.
The people up the street would have had a connection if they thought that they were reviewing something that didn't have that.
It was a very smart call out. I appreciate it. All right, let me mute things here.
He may have it
Good afternoon, Ms. Rivers. Are you back with us and ready to go?
Yes, Judge, I'm ready.
Great. Did you have a good weekend?
I did. How about you?
I did. We had our annual cookie party. So that meant lots of people in my house, which I don't like, but it also meant lots of cookies in my house, which I do like. So I think I came out all right. We are back on the record. Oops, we're not going to be back. There he is. Mr. Singleton is back, just like that, wearing his big denim jacket. We are back on the record in State versus Singleton. Ms. Wardell, thank you for indulging us over the lunch break. We're going to continue with your direct examination. It sounds like there's an hour left, but we'll get through whatever's left. Mr. Hort, when you're ready.
Thank you, Your Honor. Ms. Wardell, of your own personal knowledge, what can you tell us so far as Mr. Gishard's trial strategy if he felt there was no real defense?
We're referring, so we're clear, to the Singleton trial as opposed to some other case.
Yes and no.
Okay, then I'm gonna ask you to clarify that question.
Well, I'm referring to the Singleton trial, but it's also was our intention to get from her that this was his trial strategy. If there's no real defense, then he didn't try.
Okay, well, we're focused on what happened in this case. Were you wearing a mask before?
I was not, Your Honor.
Did something change, or were you okay?
So I'm fine.
Okay.
I was sick last week, got over that. Did not involve a headache, but over the break I developed a headache, and so.
Abundance of caution.
I did not want to
Great.
possibly give her something.
Thank you. All right. So for now, your question is about in this trial, what happened?
That's your request?
Yes.
Yes. Okay, in this trial.
Well, in this trial, I saw him do what I've seen him do before, which is if he feels like he can't win, and he said it to me that he didn't feel like he could win and get less than a felony murder charge for his client, then he didn't work very hard.
Well, you got both answers.
And that was evident.
And we didn't really talk about this, but again, going back to that case at the beginning, this was a high profile, high publicity murder case in Fulton County.
It was.
Did Mr. Gishard ever discuss with you the ballistic and forensic evidence before the trial?
No,
Do you know whether he ever had his investigator look into the ballistic and forensic evidence?
I didn't see anything that indicated he had.
Did he ever talk to you about getting an expert witness related to this issue?
No,
Did he ever tell you why he didn't cross-examine the forensic and ballistic state witnesses?
no, but he didn't believe in cross-examining anyone who would cause any harm to his case.
You are aware that Leslie's, one of the issues here is to whether Leslie had abandoned any criminal responsibility or culpability.
Yes,
What does that mean? I don't understand the question. To abandon criminal responsibility.
Or culpability. That's one of our issues, is that Mr. Gishard was ineffective for not pursuing that, for not requesting a jury instruction on that issue.
Oh, abandonment as in I am disengaging from the conspiracy.
Yes,
Okay, I got it. I thought this was,
I'm sorry.
No, it's just, I haven't heard it phrased that way, but that's your point, is that a defense would be, yes, he was present and maybe more than merely present, but there reached a point when he was, I think we call it withdrawing from the conspiracy. And you've talked about that before. I just didn't know what you meant by that. Okay.
I'm sorry, I don't want to cut you off. Did you finish your answer?
I was finished.
Okay. Did you ever talk with Carl Greenberg about the ballistic and forensic evidence or the non-cross-examination?
No,
Did you ever talk to Mr. Greenberg about this case at all?
never.
And again, your office was right next to his?
That's right.
What was your norm so far as research, staying up to date on case law, statutes, whatever?
Well, I read the daily report every day and they had a lot of appellate opinions and I read those.
So fair to say you stayed current on what was going on in Georgia on a daily basis?
As much as I could, was pretty consistent.
Was that one of the assets that you would provide to the trial attorneys?
Yes,
Did Gashard ever talk to you about the law or anything of that nature as to the Singleton case?
no,
Now, were you, one of the issues that we've raised is that it was ineffective for not objecting to a jury instruction. And when you consider the evidence in this case, if you find a conflict, you should settle this conflict if you can without believing that any witness made a false statement. If you cannot do this, then it becomes your duty to believe that witness or those witnesses you think best entitled to believe. And that's referenced to volume 4, page 1037. Do you remember back that the Georgia Supreme Court recommended that instruction not be given prior to the Singleton case?
Objection, that's actually incorrect. Like, he's asking her about the law, and it's not a correct statement.
Okay, I don't know that that's a standard objection, but I don't want us to be creating a record that I have to correct later on by saying Mr. Hort's chronology was wrong. So why don't we pause the questioning for a moment? I trust Mr. Armstrong's chronology here. I don't know when the Supreme Court cautioned trial courts not to give that instruction, but if that was after this trial date, then we shouldn't attribute to Mr. Gashard or anyone else poor performance if they hadn't received that wisdom from on high. What did you want to add, Mr. Armstrong?
They haven't.
They've never said that.
They did that in the Noggle case for a different instruction that was presumption of credibility.
Okay.
It's not present in the.
Oh, okay. So it's not a timeline here. It's that you believe that the Supreme Court has not criticized or stricken or anything like that particular charge about, hey, if there's a conflict you can't resolve, I'm streamlining it. You've got to believe who you choose to believe.
Correct.
You believe that the state of the law is that giving that when the evidence supports it is proper in a criminal trial.
Correct.
Okay.
The language that the court used here has never been overruled, and it's been affirmed multiple times, and people have raised this claim based on Noggle.
Noggle.
Noggle. It's
Okay.
an older case, I believe, from the 1980s.
Okay.
So if I could go back to my question, which might have answered his objection.
Okay. Don't read the whole charge again, but yes, go back to your question.
Did you know that before the trial, the Georgia Supreme Court had recommended that such a presumption of truthfulness charge not be used? And I reference Noggle, Noggle versus State, 256 Georgia, 383, 1986, Watley, Whatley v. State, 270 Georgia, 296, 1998.
So those are both before the trial of those cases, but I worry that maybe we're mixing and matching that presumption of truthfulness. Your contention, Mr. Hort, is that the presumption of truthfulness charge is that set of words you read into the record about when there's a conflict, if you can't resolve it, you should believe the witness you found to be most credible?
I'm saying as trial lawyers, as defense attorneys, our job is to represent our client to the best of our ability. And if you have the Georgia Supreme Court criticizing the presumption of truthfulness charge, then why not talk to Judge Downs and say, I don't think you should give this. Georgia Supreme Court criticized the presumption of truthfulness charge, and this is of the same ilk.
Okay, so you are not saying it is the presumption of truthfulness charge. You're saying armed with Noggle, why wouldn't a lawyer say, this is a close enough kissing cousin, it suffers from the same defects, Judge, I encourage you not to give it.
Yes,
Okay, I better understand your question.
thank you.
All right.
I don't believe he objected.
Okay. Do you know whether you even had a discussion with him about the Noggle case?
I don't recall.
Are you familiar with the Waters plea bargain?
Yes,
Who represented Mr. Waters? Did he have the public defender?
It was Mr. Mathis, I think.
Oh, the gentleman who dialed in.
Yeah,
Okay, he was a private attorney at the
I think he
time?
was retained, yes.
Okay,
It's my memory.
right, this was a guy driving to Alabama or Mississippi or something, okay.
Good memory. I'm sorry, were you familiar with the plea bargain?
yes,
Okay. And again, going back to 2000, the agreement that he had that he's going to get a sentence of life plus 14, but only serve 14. Your comments, your thoughts there?
not likely. He would serve more than that.
And you know, of course, that he's still in prison today.
Yes,
Does Mr. Waters have other charges keeping him in, or this is his conviction?
To my knowledge, it's just that. Mr. Armstrong can certainly correct me if I'm wrong.
He doesn't hesitate.
He does not. Okay, I'm going to read to you two portions of the transcript. There was a Merez, and that's one of the co-defendants. That's M-I-E-R-E-Z. There was a bond hearing on September 11, 2000, where the state said the two, Mr. Singleton and Mr. Waters, approached the vehicle. Mr. Merez stays behind at the driveway. They order Sergeant Grigley and Ms. Blaylock out of the vehicle and order them on the ground. They are literally laying on the pavement on their stomachs as Mr. Waters and Mr. Singleton get into the vehicle. And that's again the Merez bond motion transcript, page 8 from September 11, 2000.
And you're attributing, the transcript attributes those words to some prosecutor presenting the supposed facts of the case to the judge.
At the bond hearing, yes. Okay. Then there was another Merez bond hearing on November 28, 2000, where the state's assistant district attorney told the court, when they stumbled upon Sergeant Grigley and Debbie Blaylock arguing, it was Michael Waters who said, "This is our chance." And Michael Waters told the other two to wait at the driveway while he went in and perpetrated the crime, which you've heard about many times at this point, which we won't go back into. That's page 11, Merez bond motion from November 28, 2000. Did Mr. Guichard ever talk to you about those two statements from the state?
no, he did not.
Do you know whether there was any type of investigation by him or the investigator as to any inconsistency?
I don't know.
And I would indicate the bond hearing again on November 28. I recently received some discovery from Mr. Armstrong. And in that discovery, there was referenced an audio tape of a Waters interview by the state on November 28, 2000. We've asked Mr. Armstrong for that. I would think he would confirm that he's been unable to find that audio tape.
Unless it is the one of the two CDs from Merez that I've already given Mr. Hort. I don't believe I know of any place to look for discovering the case.
I assume
Okay, so we're in the same posture we were before.
with missing evidence,
Correct.
yes.
And I know this isn't Ms. Wardell directly, but that would be something that was tendered during the trial, or it's something that the state had because they interviewed Mr. Waters and they'd have their notes, they'd have a recording, whatever they had, it arguably would be some kind of Brady or Giglio or whatever, if it were disclosable, if his testimony were entirely consistent with it, they'd hold on to it. But it's something you have reason to believe the state had, but it's not part of the record of the trial.
The state referenced in one of the pre-trial hearings that they have this audio tape from Mr. Waters on November 28th.
Okay,
And then Austin that I believe they said they were going to send it to Mr. Gashard.
okay,
So by that, obviously, we don't have Mr. Gashard's file.
right. And Mr. Armstrong has looked through the DA's files and is not able to locate that either.
Right.
Okay.
To clarify, I turned over 2 CDs, I believe, of Mr. Waters' statements. I have not checked to see if that is germane to what it is, but I turned that over to Mr. Ford about 6 months ago.
Is that what you just said? Rewind 2 minutes. You said Merez.
Sorry, Merez, I think, was 1 CD. Waters was 2 different things. So he made 2 statements to the police at different points.
Got it. So you handed over what you were able to find, and it may in fact be the recording that was referenced that
Correct.
you don't know. You
I have
gave
not
everything.
had time to look at those things, given the bulk of work.
Okay.
And I certainly can give the court the email from Mr. Armstrong. Mr. Hort, you previously asked about a tape that was obtained from the non-testifying co-defendant after his guilty plea. I do not know of the location of that recording. Which obviously is different than what he's saying today.
Merez is the non-testifying co-defendant. There was a recording that I turned over. If that was it, then that's it. But if it's not that, I have no other recordings from discovery.
Okay.
It was when the question changed to Mr. Waters that I mentioned to CDs from Mr. Waters.
Got it. I'm hearing clearly that Mr. Armstrong has provided everything he's been able to find. If you can show that there's something missing, then there's something missing. I don't know if what you received was the same thing as what you're referring to.
According to his email, he could not locate it.
I heard what you said.
And that was in response to my email. The November 28, 2000 David Merez bond hearing transcript states on page 10, the state secured the testimony of Michael Waters and made a brief audio tape cassette. What Michael Waters would say, I would ask for a copy of that cassette.
Okay.
And that's
you have received, you have helped me. I appreciate that this is what the emails say, but I'm also hearing Mr. Armstrong say, I gave Mr. Hort some statements, recorded statements of Mr. Waters. And so if you've listened to them and you can tell either there's a date stamp on them or it says, hey, happy August 2001, Mr. Waters, that you know it's not the same thing, then you don't have it, but you may have it.
Well, I obviously will go back and look. Right now, I relied on his statement that he could not locate it.
Okay.
My email mentioned the non-testifying.
We don't need to circle around this more. I got it.
Was there ever any discussion with Mr. Gashard about exploring a plea agreement in Leslie's case?
Not that I heard.
And you mentioned before that this is something that you have done not only in life cases, but life without parole cases
Yes,
or death penalty even.
yes.
And I'm trying to remember, did we also talk about whether you thought that Sheila Ross would be open to such a discussion
Objection, speculation.
based on what was going on at that trial and you're working with her?
Would you have any reason to know what Ms. Ross would be thinking about resolving a case, or would you just be guessing or saying, well, I've worked with her before and typically she's this way? Because neither of those can come in here.
That I worked with her before?
Right. I mean, she may have done these other things in the past with cases you had, but that's not this case. If you didn't engage with her on it so that you just be extrapolating, then please say, I don't have an answer to the question.
I don't have an answer to the question.
And I would reserve under 701 lay witness opinion testimony, my objection. I'm sorry, maybe we asked and I just missed. Did you ever discuss with Gashard about working out a plea with Ms. Ross or anyone else?
No.
Did Did you ever talk with Mr. Gishard about pursuing Leslie's competency, fitness to stand trial, anything of that nature?
I didn't, but that wasn't something that the standards of decency have progressed as quoted in one of the cases on juvenile behavior. And at the time, competence wasn't an issue. It was just too bad you committed this crime and you're in superior court and you'll be treated as an adult. So I did bring it up in another case, but not in this case.
Was there anything about your interactions with Mr. Singleton that gave you pause as to his competency? I appreciate he's a juvenile, so he's not a 30-year-old, but you worked with lots of juveniles. That was your testimony.
But I did not work with Leslie.
Yeah.
So I don't know.
Well, let me ask the question different. I appreciate that answer. You did sit with him during trial for 4 or 5 days.
Yes.
Was there anything about your interactions with him during that time that made you worry, other than the fact that he is young and overwhelmed by what's going on, that made you think this is not just a 16-year-old, but this is one with a mental health challenge or a functional or cognitive deficiency?
No, there was not.
Okay.
Does that surprise you?
Yes.
In what way?
Generally speaking, these juveniles are very confused, not very helpful at trial, don't really understand what's going on, and really could be considered incompetent to stand trial to assist in their defense.
Now, is that based upon you meeting with them, talking with them, finding out as much as you can?
Yes.
And in this case, none of that happened.
No.
You know now, but you did not know then about his family life, what he did on a day-to-day basis, any of those things.
No.
And I'm guessing that's not the type of thing that Leslie would have told you on a recess.
No.
Wardell, let's talk about me a minute.
No.
So all you had was sitting at the same table.
Yes.
Did you ever talk with Mr. Gishard about requesting a jury instruction on perjury, immunity, or leniency granted to a witness?
No, I didn't.
Did you even know until it came out at trial that Waters had this plea bargain?
I did know about that.
Did or did not?
I did.
And how did you know about that? Is it something you talked about with Gishard or some other way, or?
I don't recall at this minute, but I knew.
Okay. Did you ever talk with Mr. Gishard about an abandonment instruction?
No.
Did he talk to you about any of the jury instructions that he was going to request?
No, he didn't.
Was that something that typically happened when you tried cases with him?
Yes.
Why is that typical?
Well, you want to know what's going to be read to the jury for them to use the basis of their decision.
Well, I didn't ask my question well then, if that's what, my question wasn't, was it typical to have a charge conference? My question was it typical for Mr. Gishard to consult with you? Hey, I'm not good with jury charges. You're more well-read in Georgia law. I'm from Illinois. Would you help me think through which jury charges to use?
That is something we did together on many cases.
But not in this case?
Not in this case.
Okay.
One of the issues we're raising in our motion is missing transcripts. Were you present at any of the hearings before the trial?
No.
Do you remember anything about a Jackson Dental hearing or any hearing related to the state's filing of an intent to present evidence of similar transaction and motion in limine? Were you even aware of those?
I don't know anything about that.
Okay. Do you remember anything from the first day of the trial, whether there was any motions heard before jury selection or what took place on the first day?
I don't remember specifically, no.
Okay.
They frequently were.
Did you ever talk with Mr. Gishard about the Detective Martin's promise to Leslie to get his mom out of jail in return for a statement?
No, we didn't talk about that.
Did you even know about that, or did it ever come up in any way?
Had I had any idea, I would have been working on this case.
Would or would not
I
have?
would have, but I didn't know that. That would have jumped out at me.
Did you ever talk to Mr. Gishard about the use of force, pressure on Mr. Singleton or any of the co-defendants?
I don't recall.
Was there ever any discussion that you were part of with the investigators so far as looking into that or anything of that nature?
I don't remember.
Do you remember even knowing about this before the trial?
No,
Do you remember hearing it during the trial?
of course.
How would it have come out? How would you have known about it at trial?
I'm sorry, could you ask that question again? Because maybe
Sure.
I misunderstood.
And we're talking about the use of force against Mr. Singleton or any
Oh.
of the co-defendants.
I'm sorry, I did not know.
Okay, so you did not even know about that until,
No,
did Mr. Gishard ever talk to you about any of the information that he had received from Leslie before the trial?
a little bit.
Do you remember what, if anything, he would have said?
Well, he described the case to me. We did talk about the facts as he had them, but we didn't talk about a lot of these other things that you're bringing up.
Do you remember what,
Force used against Leslie, the coercion, the fact that he was trying to sell drugs to get his mother out of jail. I was aware of that.
do you remember
But
what he
not
did
until
tell
the
you?
last minute.
Do you remember what he did tell you? I realize again, it's
That-
23
well,
years ago.
Yes, but I remember the gist of it was that it was going to be a felony murder, party to the crime case, and there wasn't much he could do for the client. And I knew what that meant.
Did you ever talk with Mr. Gishard about the how and why Waters got the gun?
I did, yes, I knew that. He told me.
What did Gishard tell you? Do you remember?
Well, that the gun had been found by Leslie in a book bag thrown down by an maybe off-duty police officer in Clayton County.
Mr. Gishard ever talked to you about checking this out or investigating what happened there?
No,
To your knowledge, did the investigator ever look into this?
I don't know,
To your knowledge,
not to my knowledge.
did Mr. Gishard ever talk to you about looking into the Clayton County case so far as Officer Populus? That's Populus.
He did not.
And to your knowledge, did the investigator ever look into that?
I don't know,
But to your knowledge, did he?
not to my knowledge.
Do you know anything about the juvenile assessment conducted by the Department of Juvenile Justice?
Well, I have seen it, but I did not see it before the trial. I didn't know it existed.
So I assume by that, Mr. Gishard never talked to you about that or showed it to you or anything of that nature.
No, think I remember he wanted to keep that out. But I don't remember. That was in a pretrial motion or how he handled it.
And that very well could be that similar acts motion from the state. Do you remember him ever talking to you about what happened in the motion or how the judge ruled or what they agreed upon or anything of that nature?
I wasn't present.
Let's talk about Mr. Greenberg. I believe you said that he also then would have left the conflict office the end of 2004.
Yes,
Do you know up until that time frame whether he ever communicated with Leslie?
I have no knowledge of that.
Do you know anything about Leslie filing grievances against Mr. Greenberg?
Objection. Never mind.
I'm familiar with that, yes,
And how or why were you familiar?
from what I've learned since.
Okay, so you never had that.
Objection, basis for foundation for knowledge?
But let's not, it sounds like this would have been, hey, someone was telling me about the case, let's explore a different area. Unless you think there is a proper's the wrong word, but an evidentiarily admissible basis for Ms. Wardell knowing about this.
I just was going to ask whether Mr. Greenberg ever talked to her about the grievances that
He
Leslie
did not
filed.
tell me. I wouldn't expect him to.
What about, do you have any personal knowledge as to whether Mr. Greenberg read the transcripts?
I never saw him read a transcript. I can't say what he did read.
And to your knowledge, again, was there ever any discussion between Mr. Greenberg and Mr. Gishard about Mr. Singleton's case?
I don't know.
Did Mr. Greenberg ever talk to you about Mr. Waters refusing to testify in the Clayton County case, which took place right after the Fulton County case?
No,
Did you know anything about Mr. Greenberg's mental health issues?
I know him pretty well. We were friends as well as coworkers. I would imagine that he has regrets.
And Your Honor, I'm sorry. The next question I was going to go into was with regards to the Michael Lewis case. Had you decided on that, or is that next to come up, or do you want to hear what I was going to do? Or
So you want to ask Ms. Wardell about a case that is not, this case is not connected to a defendant in this case. So not, well, what about Mr. Waters' other situation or the gentleman Perez, but a completely different case that involves Mr. Gishard?
I wouldn't say completely different. It involved Mr. Gishard, and it took place at the same time frame as the Singleton case.
It's not connected in any way factually to the shooting death of Mr. Gridley.
Other than Mr. Gishard's conduct.
Okay, all right, then that's not what we're gonna cover.
Okay. Can I then give you an offer of proof on that?
Sure.
Your Honor, can I ask if it needs to be in front of a witness?
It doesn't, no, we'll do that after Ms. Wardell, let's finish up questions for Ms. Wardell so she can be on her way.
And then I also would present an offer of proof based on the court's comments so far as like cases involving Carl Greenberg, whereby he did not pursue the appeal and the cases ended up being dismissed by the trial court. But I didn't do that after she.
Likewise.
Okay, no other questions at this point.
All right. Mr. Armstrong, before you ask any questions, you have them. Ms. Cox?
Yes.
Just wanted to thank you for your patience. I've signed this and approved it, so you should be able to file it, and I wish you the best with this.
Thank you so much.
Tough time of year to be working through this. Good luck.
If I stand at the podium, will I be blocking? Will I block your view of the witness?
Oh,
if I
don't
stand-
worry about it.
Okay.
Wherever you're comfortable is fine.
And on the screen, you'll be able to see the witness.
Ah, there we go.
Thank you, Zoom.
Ms. Wardell, good afternoon.
Good afternoon.
If, because of this mask, you don't understand something that I say, please just ask for me to clarify. And Ms. Rivers, if at any time it sounds like you can't understand what I'm saying because of this mask, please let me know. And I can possibly take it off. Ms. Wardell, I'm just gonna go over things in the order in which you testified, so it might be a little back and forth.
All right.
And you testified that you did an internship while you were working while you were getting your law degree. Was that correct?
Yes.
You testified it was with the Georgia Public Defender Standards Council, but that's not the name of the organization at that time, was it?
It was called the Felony Trial Division.
Okay. Okay. What year did you graduate from law school?
94. I went to school in my 40s.
Okay. Could you just chronologically, because I wasn't quite clear on when things happened, up until the end of 2004, can you tell us the different years of your career? Of when you changed jobs? Because you
Okay.
testified to multiple things and I just wasn't clear on when things had happened.
Sure. I started interning after my first year of law school. And what year would that have been? I graduated in 94, 91, I think. And so it would have been 92, more or less, 92 and 93. I interned at the Mental Health Advocacy Division, MHAD, of the Georgia Public Defender Standards Council.
The Felony Trial Division?
No, the Mental Health Advocacy Division.
What-
I'm not sure exactly because these were groups that all worked in the same building. And we
Okay.
were all under the Georgia Public Defender Standards Council. So I'm not sure if Mental Health Advocacy Division was associated with felony trial or the Standards Council.
So let me stop you for a second.
Mhm.
I thought the Georgia Public Defenders Standards Council came into being on January 1st, 2005. I thought that's what replaced the organizations that you were in
The
until the end
felony
of
trial,
2004.
okay, well, maybe I'm wrong about that. There,
Okay.
we had a different director at first.
Okay. Who is that?
Oh,
This was before Paul Keir.
yes, this
Okay.
was, yes. Felony trial division
worry about his
had a
name.
different, and I can't think of his name,
Okay.
but he was dismissed after a while.
So I believe you testified that you were with the Conflict Defender's Office for 7 years.
Yes.
Do you know when that began?
97.
Okay.
Well, that's only 5 years.
Well, 2004, 2003, 2002, 2001, 2000, 99, 98.
Right,
Okay. So that's 7 years,
yeah.
more or
okay,
less.
Yes.
And what was it you did between graduation in 1997? I was a little unsure about what happened then. I apologize.
Oh, well, they hired me to work in the mental health advocacy division.
Okay.
And I was hired by, his name is Eric Kocher, Kocher. He was the director of the felony trial division. And he hired me to work in mental health advocacy, which I'd been working in the past 2 years, part-time.
Okay. Do you recall whether Gary Guichard was already working there when you began there?
He was working with the death penalty group, which was in the next office.
Do you recall what year he came over to the Capital Defender's office?
I don't.
Okay. Do you remember about how long you were there before he came over?
Oh, I think he was there a couple of years before they hired me. So I think he was there.
I apologize. I'm asking you a different question. I'll try and be better at the question. You indicated he was in the next office over the death penalty one when you started.
One of the death penalty offices was next to me, so I was aware he was working with them.
Do you remember how long you were at the conflict defender's office before Mr. Guichard came to the conflict defender's office?
I don't remember.
Okay. Do you recall when Carl Greenberg joined the Capital Defender's office?
He didn't join the Capital Defender's office until 2005 or later, when they closed our office. He was with the DA at the time. He worked for Paul Howard
So when did you work with Mr. Greenberg?
for 7 years.
But if he didn't start working at the Capital Defender's office until 2005 and you ended in 2004, there's no overlap.
No, we both started working for the conflicts office. They just changed the name of these things, but.
Do you remember when Mr. Greenberg started working there?
97. He started the same time I did.
Okay.
Greenberg or Guichard?
Greenberg.
I was asking about Greenberg.
Okay. So he was there the entire time you were there. Mr. Guichard joined after you'd been there for a little bit.
Mr. Guichard joined felony trial, the conflict defender's office a year before I did. And then when I joined the conflict defender's office, Carl Greenberg joined at the same time.
Got it. And you were paired in part with Mr. Guichard, so you get trial experience.
Yes.
Okay.
All right. Going to ask a follow-up question to what he asked, but first, since I'm going in order, I believe you testified that back around the time of this case, that SB 440 cases were not transferable to the juvenile court for murder cases. Was that correct?
I don't know if that was strictly the case, but I never saw one transferred.
It was your understanding of the law that
It
for
was
murder
my
cases.
understanding at the time, yes.
Okay. Now, Mr. Guichard became your trial partner. You testified earlier, I believe, that when you started working with him, that you didn't have trial experience. Is that correct?
Well, I had worked at hearings, many hearings with NGRI, acquittees, and that sort of thing, but I hadn't done a trial by myself.
Okay. How many trials by yourself have you done since starting working with Gary Guichard?
Not very many. I did several things that were strictly mental health hearings before a judge and expert witness hearings and that sort of thing, but I did never do a trial from start to finish by myself.
Now, when you say by yourself, does that mean as the lead or just by yourself with no second chair?
Oh, no, Gary was always second chair. If I did what I did, he was always there with me.
But it sounds like you didn't do very many trials.
No,
And so, okay.
it's not my strength.
Early on, you testified about your dealings with individuals that you used a phrase, seriously disturbed individuals. Is that a term of art for you, or is that just something that, how you were describing it?
Well, it depends on what age you're talking about. I had SB 440 kids who were developmentally disabled, mentally retarded. And those were seriously disturbed kids.
Okay.
13 years old and mentally retarded and really not responsible for a lot of things they did.
So the testimony that you gave about seriously disturbed individuals, that applied specifically to individuals with those kind of issues?
Not specifically, because you might have somebody who is severely traumatized. It could be an adult. Situations where you need an expert witness to assess them and find out, a psychological testing, for example.
Okay.
I did the screening and I would determine what kind of expert we would need for that kind of client. And then we would get an expert to work on the case.
I think there's somebody else on the thing now.
Yeah, it was Miss Allen, the bunny Allen, but I muted it.
When you're testifying about seriously disturbed individuals, you testified that, but that doesn't go very far with people who are under adult standards. Were you testifying about how worthwhile what it is that you do for seriously disturbed individuals doesn't go very far for adults, for people in adult court?
Oh, no, it's similar for adults, but you need to have a competency hearing. And I did have a competency trial for one of my SB 440 clients who was seriously disturbed. I mean, he was developmentally disabled.
Okay.
And that changed the course of the case. But it was not a common thing to say that, for example, a 15-year-old is incompetent merely because he's 15. That would be my argument in a lot of cases, but it wasn't something that really worked when we were dealing with SB 440 cases, unless they were truly incompetent for a reason other than their age.
Okay. I believe at one point you testified that your memory was not so great. Is that correct?
My memory from 23 years old ago, 3 years ago, is not so great. No.
Okay.
I'm 78 years old.
I understand. So when you testified that you could not recall something, that's just something that you couldn't recall, not that it didn't happen. Is that correct?
Yes.
Okay.
A lot of things happened that I didn't know about.
Okay. I believe you testified that in this case, you were only involved insofar as taking notes from Ms. Gishard. Is that correct?
Exactly.
And
Okay.
you also testified that ordinarily when y'all were trying a case together, y'all would talk about jury instructions. Is that correct?
Yes.
Is that generally in cases where you were more involved as a trial attorney?
Well, we would go to the scene and reenact the crime, and we did all kinds of things together on cases we worked on together. And I spent hours and hours and hours with the client. So this was not a typical case for me at all.
Okay.
And this would be a typical case with Mr. Gishard, or you're describing experiences you had with other lawyers from that office?
With Mr. Gishard.
Okay, so there were times when you and he and an investigator would go to the purported crime scene and try to reenact it?
Yes.
But that didn't, it may have happened in this case, it didn't happen with you.
I wasn't involved in that.
Okay. I believe you testified about both you and Mr. Guichard having 20 to 25 regular cases and 2 death penalty cases at a time.
Yes.
Are those, you each had that number of cases, or y'all had those exact same cases?
No, they weren't the same. They were separate.
Okay. You testified that at some point in time, Mr. Guichard came down with narcolepsy.
Yes.
Did that get worse over time, or was it the same throughout your time with Mr.
It
Guichard?
seemed to get worse.
Okay. Do you recall when you first noticed it?
Well, I couldn't understand why he seemed to be sleeping at times when sometimes we were just talking and he would say, "Oh, I was just thinking." And
Well,
I
do you
would nudge
recall-
him to wake him up.
Do you recall when that began?
I don't.
Okay. You
Yes,
testified
sir.
about Judge Downs calling him up to the stand at some point when he fell asleep in court. Do you
Yes.
recall that?
Yes.
When you say called him up to the stand, do you mean the podium where I'm standing now or?
No, up to the bench. I meant
Okay.
the bench.
So it was something that she addressed when it occurred?
Yes.
Okay. If you saw him asleep in court, did you wake him up?
Oh, yes.
Okay.
And I always sat next to him.
Okay. So do you have any specific memories of him being asleep for any particular part of this trial in March 2001?
I don't remember when, but I'm sure he did because he always did.
When you say you're sure, I'm asking, do you have any specific memories of him being asleep in this case?
I can't say exactly when.
Well, do you have any memories, specific memories of being
Yes.
asleep in this case?
Yes.
What part of the trial was that?
I can't remember.
Okay. Would you have woken him up?
Yes, I would nudge him.
Okay.
But that didn't mean he had heard what was said while he was asleep. And that was what's so upsetting about it. There's
Okay.
not much you can do in the middle of trial.
Did you ever report that to Mr. Keir?
No, I didn't, but I know the investigator did.
You know the investigator reported that to Mr. Keir?
Yes.
Okay. You testified that Mr. Greenberg was a very lazy individual, correct?
Yes.
But you don't know when it was that he would read transcripts, if he read transcripts.
I don't know. I never saw him.
You testified that you investigated and determined that he had done, I believe you said either 7 or 17 cases in 7 years.
17 cases in 7 years.
How did you make that determination?
I can't remember now, and I've tried to remember, but I don't remember how I did it. But it was available. The information was available of the appellate cases, how many were his.
Okay. If there are 26 appellate cases with his name as the appellate attorney in 2002, 2003, and 2004 on Lexis, would you have any reason to contest that?
No,
Okay.
we didn't have Lexus.
What did you have?
I can't remember what I used, but I did investigate it. It might have gone through the Fulton County Daily Report or something.
Okay. You testified about an effect that the Butts County case
Mhm.
had on your office.
Yes,
Okay. Now, is that an effect that it had on your office when it happened?
when it came out, Gary told me about it.
I'm not asking you what the circumstances of the case were.
Mhm.
But I am asking, do you know when it came out and how it came out?
It came out to me through Gary,
Okay.
but our director, Paul Keir, also mentioned it to me.
Okay. And I believe you testified on direct that it was well known.
Yes,
Okay. You said there was a drop in his cases after that, in the number of cases that he was handling.
I don't know if it was the number or the character of them.
Okay. Do you recall when that happened?
I didn't put it together at the time, so I don't.
When you say put it together, does that mean that you have
I didn't,
assumed that the reason his cases changed was based on this?
yes, but I wasn't told directly that was the reason.
Okay. Was that closer to the end of your time together or at the beginning of your time together?
Closer to the end.
Okay.
I was doing a lot of other things in the office, so we weren't working as closely together anymore.
Okay. You testified that Mr. Bouchard appeared to be angry at Singleton because Singleton had lied to Mr. Bouchard.
Yes,
So that presumes that Mr. Bouchard talked to Mr. Singleton about the case, correct?
yes.
Okay. You testified that Mr. Waters was the leader in this case, correct?
As far as I know.
Okay. Were you aware that Mr. Singleton, without Mr. Waters, committed an armed robbery of an investigator the day before or 2 days before in Clayton County?
I know of that, yes,
And Mr. Waters wasn't present for that, as far as you know.
correct.
So Mr. Waters was not leading Mr. Singleton into that.
No,
And you're aware that Mr. Singleton gave that firearm to Mr. Waters in this case?
yes,
Okay. You testified about the benefit of an expert explaining why a juvenile might lie to protect his friends, correct?
yes.
Okay. Was Mr. Singleton charged with lying?
Not
your
that I
memory?
know of.
Okay. Would that change would an explanation for why he lied change the fact that he lied?
No, and that's why we didn't use experts like that.
Okay. Something buzzing, I apologize.
I'm sorry, it's something over here, but I've got it.
Oh, it sounds much closer, I apologize.
Yeah,
I had the
I
phone
don't have a
turned,
phone out here.
I have the phone turned off, but
You're good. It's all right.
I thought it was me because I thought it was right here. That's why I was concerned. There was a question and an answer that went by pretty quickly, and I'm just asking for clarification if I understand correctly. Mr. Hort asked you if Mr. Guichard encouraged Singleton to lie at trial, and you testified that he did not. Is that correct? That's not a trick question. I just I hadn't expected that question.
I know that he did encourage him to lie at trial,
Encourage him to lie in what way?
to say that he was coerced. That was in his notes.
So when you say this, you're saying that Gary Guichard tried to get Leslie Singleton to say that he was coerced.
Yes.
And
I don't know what Leslie's response was.
okay. How do you know that that was a lie? That he wanted him to lie to say he was coerced?
He must have told me.
Okay.
I don't remember. I just knew.
He, meaning Mr. Singleton told you that, or Mr.
No.
Guichard told you?
Gary Guichard told me that.
Thank you. Did you ever suggest a different trial strategy, such as a different defense in this case?
I didn't have time. I did not. I didn't even realize this was a juvenile case.
You testified that Mr. Guichard had determined that he didn't believe he could get less than a felony murder in this case.
That's what he said.
Okay. You also testified that he did not believe in crossing anyone who would bring harm to his client. Was that correct?
Right.
Can you tell us about that?
He didn't like to call attention to bad facts. And he also felt that if something was harmless, he would just let it go rather than object.
Okay.
But that could be taken too far.
You were asked about the Waters plea bargain. Were you in court when the defense for Mr. Waters announced spontaneously that he'd be pleading guilty?
I don't recall.
Okay. This was a pretrial hearing. I apologize. Were you present for any pretrial hearings?
Not that I recall.
Okay. You testified about competency issues, and I might be wrong, but there appears to have been a difference between competency as we understand it for adults and competency for juveniles. Were you testifying about a different version of competency than what we're familiar with in adult court?
Well, really, there is a definition of competency. And if you're not able to assist in your defense and you don't understand what's going on at trial, you're not competent to proceed. But to bring that up with a juvenile was really redundant, because people know just of their own knowledge that juveniles aren't adults, and they don't think like adults, they don't act like adults. But bringing it up as an issue without more, for it just being an average 16-year-old, for example, was pointless, really, back then, because it was sort of, you've done the crime, it's a murder, therefore you're in superior court, and that's where you belong. And there wasn't any question of what you're going to do with that. He was incompetent, and if he'd been legally incompetent, and we'd send him to the state hospital to be made competent, I guess that could have been done, but it wasn't. I only did that with my client who was developmentally disabled.
So did you just testify that bringing this up at that time would have been pointless?
Yes.
Okay. You also testified about your impression of Singleton from sitting beside him.
Yes.
You testified that you did not do any kind of evaluation of Mr. Singleton,
I didn't.
but you testified that you were surprised by his lack of mental health issues. Is that correct?
I can't say I was surprised by his lack of mental health issues, but I didn't notice anything.
Okay. When you testified earlier that no mental health issues and no cognitive deficiencies that you noted in him, and that this surprised you, what did you mean by that then?
I'm sorry, I don't remember saying I was surprised, but he was pretty sharp for a 16-year-old.
Okay.
But that was just judging by sitting beside him in court and talking to him at breaks. So.
Thank you. Now, you were asked questions about a promise to get the mother out of jail. Would it change your answer to no, it was to get her from the jail to be present for the interview with Mr. Singleton?
I didn't know that.
Okay. Would it change your opinion on how concerning that was? Because you testified it was concerning the promise that they would get his mother out of jail, and
Yes.
that would cause you to do certain things. If it was to have the mother present for the interview with Mr. Singleton because he was a juvenile, would that change your opinion of how concerned you would be about it?
No, it wouldn't, because the idea that you've got a teenager trying to get his mother out of jail, it puts him in a fairly desperate situation. And I would have worked on the case had I known that but that was a fact of the case.
Okay. Would it be better or worse for the juvenile to have a parent present while speaking to police?
Well, better, assuming it's got a reasonable parent.
Now, I just want to clarify a thing, and I think that you already clarified this on direct, but the testimony was that at no point during this trial, either from the evidence or from Mr. Singleton, did you hear anything about a use of force in order to get his statement? Is that correct?
In order to get his statement?
Correct.
There must have been notes or something, because I knew about it. I know about it, but I don't know if I knew then. I can't tell you.
You don't know if you knew then?
I don't think I did.
Now, would it be based?
I just don't remember.
Don't talk over
I apologize. Would it be based on what the defense has talked to you about the case for this hearing that you might know that information?
No, I read the transcript.
Okay.
It might have been, I think I read the transcript. It might have been a long motion. I'm sorry, I really don't remember where I learned
Can
that.
I ask how you got that transcript?
Oh, I would have gotten it from Mr. Horton.
In preparation for this hearing?
From David, yes.
Okay. So you might have gotten this information in preparation for this hearing.
Oh, yes.
So it wasn't something that you knew in 2003 or 2001?
No, I really don't remember, and I'm sorry, but I don't remember
Okay.
when.
Now, I apologize to return to something. I'm just going in order.
All right.
I believe at one point, you testified that this was a felony murder party to the crime case, and there was not much the defense could do.
That's what Gary told me.
Okay.
He didn't tell me it was a teenager.
You testified about a juvenile assessment by DJJ, and you said you didn't see it at the time of trial. What have you seen since trial about a DJJ assessment?
It seemed like it was focused on his family life and not much more.
Would it be a mental health report that you're referring to?
It didn't seem like a normal mental health report at all. It seems pretty short.
Do you remember who you received this document from?
I don't.
Do you remember if it was this year?
I just don't remember. I'm sorry.
Okay. Have you ever worked as an appellate attorney?
No.
Okay.
I've worked on appellate cases doing mitigation.
Okay. You were asked a question about Mr. Greenberg's mental health issues. I am unaware of those mental health issues. What were you referring to? Or what were you agreeing when asked about?
A psychiatrist said that he is unable to testify.
So that's a modern thing from this year.
Yes.
So that wasn't when y'all worked together.
If he had mental health issues, I didn't notice them, and I would spend a lot of time with him, a fair amount of time with him.
No further questions, Your Honor.
Can you redirect, Mr. Hort?
Yes, Your Honor, thank you. I understand you correctly on cross. You essentially said that competency was a non-issue with the state of the law in Georgia that juveniles just went to Superior Court.
Well, it wasn't raised because it was a given that they were teenagers, that they weren't going to be able to assist in their defense, not able to comprehend the circumstances in which they found themselves. Some of them were 13 years old. They were just little kids.
Now, does that explain why Judge Downs ordered this juvenile assessment? Wouldn't that be a suggestion that you thought?
Assuming facts, not evidence.
Well, it's a document we received from the state, so I didn't know that he would object to what he gave us.
Yeah.
I should say not from Mr. Armstrong, but when the court found the court file and let us know, we went down to the courthouse here and got that from the court file.
And remind me what document we're talking about?
I'll pull it out right here. It's in order to assess defendant for bond supervision and social services prior to adjudication, ordered September 18, 2000 by Judge Downs and served by Sheila Ross Finley on the attorneys.
Okay. In your question in connection with that?
Wouldn't that suggest that Judge Downs wasn't completely foreclosing the idea of competency as a possible issue?
I guess so. It was
So,
for
so
bond.
before you answer, do you know what that assessment is all about? Or you're assuming because of some words in it that was, rather than figuring out what could, I don't know that it was called DJJ back then, but what services would be available for Mr. Singleton should Judge Downs decide to give him a bond? So sort of a pretrial assessment for suitability for DJJ supervision, as opposed to, I, Judge Downs, have observed Mr. Singleton, his behavior is erratic, and I think there is a competency issue. Are you in a position to say it's for the latter rather than the former?
Well, my point is, when a high publicity case involving a juvenile charged with murder, for the judge even to consider bond tells me that she is not completely foreclosing this person's mental health.
Okay. If that's your basis for relying on that document to ask that question, we need to move to a different topic.
Okay. Does the court want that as an exhibit?
Well, I'm aware of it.
Okay. Again, thank you for finding the court file, or at least part of it.
We found what we could.
Okay, Mr. Armstrong, I asked you about cross-examination. Would it then have been appropriate for Mr. Kishard to cross-examine the forensic and ballistic witnesses?
Yes.
And if he decided not to, based on his trial strategy, would it then have been helpful to investigate or possibly have an expert witness look at that ballistic and forensic evidence?
He did it on other cases. I'm sure he would have if he thought it was necessary. I'm not sure he would have. I'm sorry. I don't know.
And to your knowledge, it did not happen here.
No.
But it sounds like, Ms. Wardell, what I'm understanding from your experience with Mr. Kishard is that he would assess, let's just take ballistic evidence. Here's the evidence in this case. It is not good for us. And so I am not going to do it. The state's going to ask their questions. I'm not going to get up there and try to pick a fight, because I would really like us to move on to something else, because this is bad evidence for us.
He did that too. Yes.
And not just in the Singleton case, but in what you saw generically, not specific cases, but he would look for the warts or the wormholes in the apple and say, I'm going to stay away from those. The state may go there, but Mr. Kishard's approach is, I'm going to focus on other things. When there were other things, this may be a case where there may not have been anything you wanted to focus on.
That's true.
Okay.
I agree.
And to your knowledge, you know whether he even did that in this case?
Did what?
I don't
you
know what
said.
he was thinking.
But he never talked to you and said, hey, I'm not going to do this, or hey,
No, he didn't.
we don't want to, or,
No,
and so far as you know, he never even had his investigator look into it.
not as far as I know. I didn't have it in the file.
Mr. Armstrong said that the officers promised to get Mr. Singleton's statement was just to get his mom present there at the interview. I would offer to the court what's been marked as Defendant's Exhibit M. It's a, if I may finish,
Just
please.
let him finish. Okay, Mr. Hort, let's go.
Thank you. It's a transcript from the Clayton County cases. It involves a direct examination of Mr. Singleton's mom and also Detective Martin, who obtained the statement from Mr. Singleton.
Is
I
this
have
something you've shared with the state?
Yes, I communicated with Mr. Armstrong about getting this admitted as a stipulation, and he said, no, he first wants to look at the transcript himself.
Okay. Have you had a chance to look at the excerpts from the Clayton case?
So because they're excerpts, they leave out information of the person's testifying. And so I think that it's perfectly appropriate if we want the whole transcript from the trial to come in. I tried to get that from Clayton, but I was unable to get it easily. And so I will redouble efforts to try and get his trial transcript from his Clayton County case. My objection to doing this while the witness is on the stand is that talking about it while the witness is on the stand could affect her testimony. And I would suggest that only her information come out during her testimony.
As opposed to what happened elsewhere to which she was not privy. Okay, and I understand. So you are making an important point, but sort of through Ms. Wardell in a way that I don't think is proper. I don't know what was said in the Clayton case. Confident Ms. Wardell doesn't know what was said in the Clayton case, but that may be something I do need to know about so that it clears up. There is a disagreement, it sounds like, between the two sides that has nothing to do with Ms. Wardell about whether a detective said, I'm gonna try to get your mom out so she can be with you for this interview, which says to me, this is the state's version, she's going back to jail after she sits with you in this interview, which is very different from the way you've characterized it, which is that there was a promise of benefit. Talk to me about the killing of Sergeant Grigley and we'll get your mother out of jail, full stop, as in she's not going back after you get to see her for 5 minutes. Two different things. We need to talk about that. I'm not sure what that has to do with Ms. Wardell, because she has said, I believe consistently, I don't know what promises were made, if any, to Mr. Singleton to sit down and have that conversation. Mr. Gishard may have known about that or should have known about that. But I believe Ms. Wardell's testimony has been, I was unaware of that. And that fits because she's been very clear. I was grabbed at the last second and said, you're going to sit with me during this trial. And all she had an opportunity to do was to review a very spare case file.
Your point is well taken, except Mr. Armstrong in his cross-examination implied to this court that it was only to sit for purposes of the interview.
But that's a court thing. He did say that. I agree. That's not a Ms. Wardell thing. So I like to leave her out of the Hort Armstrong dispute about what was promised or not promised to Mr. Singleton about that interview. We've got a witness coming up, we may not get to today, who can speak very directly to, here's what the detective told me would happen to my mom if I spoke with him. That's not Ms. Wardell.
That's fine, but then I would still offer Defendant's Exhibit M to the court at this point, because again, you're not a jury.
I will take M. I will invite M prime, which would be the rest of the transcript, should you be able to track it down. I'm well aware of Rule 106, and so I'll take M in the for what it's worth category because it's not the whole thing.
Thank you.
Is Mr. Byrne Stephen Byrne? Is that who represented Mr. or is that the prosecutor?
Got a thumb up from the defendant.
Oh,
Leslie.
Okay,
Leslie.
Stephen Byrne was his lawyer for the Clayton case.
oh, okay. I wasn't sure if he wanted to talk to you or if he just was agreeing. Okay.
All right, M is in.
So for the court's edification, page 122 and 123 are the the examination of Mr. Singleton's mom, and 132 is the examination of the Detective Martin.
Okay.
And I obviously do have more pages if Mr. Armstrong wants me just to submit, in addition, all of the pages from this conversation.
What I heard Mr. Armstrong say is he'd like to see the whole examination, cross and direct, and maybe redirect, because there could be a more complete story. And that's what I heard his concern was, not that this is inadmissible, just that it could be only part of the tale.
I was just suggesting, since he had problems getting it, I was able to get it from my client's family. I can send him in total what I have.
Great.
If that's,
Sounds like that would streamline things. Thank you for that offer.
let me quick make a note.
But we've got poor Ms. Wardell sitting here. Let's pivot back to her.
Okay, thank you.
Okay,
Still with us?
I'm fine.
I can see why I like this judge. Now, Mr. Armstrong asked you about, that you didn't recall things, in essence, suggesting that it didn't take place or could it take place, who knows? Were there certain things, though, in this case that you absolutely would have recalled if you would have been involved?
Oh, yes.
Can you tell us what that would be?
Well, a lot of the police treatment of Leslie, and the fact that it wasn't cross-examined during testimony. As I said before, the fact that he needed to get his mother out of jail. The information in the bond report about his family, all of that, had I known any of that, I would have worked on this case. Gary just said, I'm keeping this one. There's not much to it. I can't do much for it. And I don't think there's any mental health issues. Well, mental health just goes with being a teenager. So I should have been on the case, but I didn't realize it was SB 440.
So again, those are things specifically that you would have recalled if you would have been part of that conversation.
Oh, yes.
Mr. Armstrong also asked you about the sleeping And whether it's possible that that could take place without you knowing that he was sleeping. Remember those line of
But
questions?
whether Gary could have been asleep and I not noticed?
Right.
Oh, I noticed.
Okay. Well, let me ask you this. One of our issues is the many non-objections to leading questions.
Yes.
Is it possible for any of those that he would have been sleeping and you didn't realize that?
That might have been when he was sleeping. I can't say, but it didn't make any sense that the questioning was going that way, all leading questions. That might have been what it was. I know he fell asleep.
Now, he talked about juvenile behavior and in essence that it would not have served any benefit to have an expert witness at the trial. Remember that discussion?
Well, I don't know if it would have been admissible to have an expert witness at the trial. I would have to have been aware of some problem that Leslie had that an expert could attest to, but I wasn't. And I don't know that Judge Downs would have just allowed an expert witness to talk about what teenagers are like.
Again, we all know that everybody in the defense bar loved Judge Downs.
That's right.
What about an expert witness? Wouldn't that have been helpful to explain why Leslie ran up or went up to the car, even if in a slow jog?
It would have been, yes.
And I recognize that an expert cannot offer conclusive testimony so far as to intent or the lack thereof. But wouldn't an expert then have been helpful to show whether his actions were something that you'd expect from juvenile behavior without thinking, or that something in that area
Yes.
using that expertise?
Lack of foreseeable consequences, that sort of thing.
Okay.
Yes.
And maybe why a juvenile would have actually jumped into the car, or why a juvenile would have done this or done that or whatever. Again, realizing the limitations with an expert witness at that time, and even now, couldn't an expert witness have helped in those areas?
To explain why he did it, yes.
Thank you, Your Honor.
Anything else?
No, Your Honor.
No? All right. Thank you, Ms. Wardell, for
Thank
your
you.
time. It's good to see you.
Thank you. It's good to see you. We had a couple of cases together way back.
Way
then.
back when?
And I remember thinking, that's the smartest DA I ever met. And he was.
You're
And
embarrassing.
now you're the smartest judge.
Okay. You didn't treat me like that back then.
I did compliment you on your savvy. You were very sharp.
All right.
I'm sure she let you know that her husband went to Harvard Law School.
Oh, there you
And
go.
Harvard undergrad too.
Just like I try to bring in every time I can, and my daughter went to Harvard Law.
So, I'm happy to keep going. Are you good to call your next witness? Anyone need a break? Nope, let's do it. Are we good with presiding matters?
Yes.
Nice and quiet?
Yes.
Those folks who came in didn't,
They're looking for, AG and all of it.
great, we're not AG, so we're good. All right, next witness.
Tony League.
Come on up, sir.
Raise your right hand. You swear or affirm that the testimony you will give will be the truth, the whole truth, and nothing but the truth, says God.
Yes, sir, I do.
Go ahead, have a seat. Can you state this clearly and correct?
Good afternoon. My name is Tony Allig, A-L-I-G.
Can you likewise give us a brief background, your experience, your history?
Yes, sir. After graduating from college, I went into service as a federal special agent, initially starting my career with the Department of Veterans Administration, Office of Inspector General, followed by NCIS for several years, before continuing my career as an FBI special agent in the Cincinnati division and subsequently the Atlanta division. That spanned approximately 30 years in total. After that, I went into, upon retirement, I entered into a corporate security role as a vice president in a Fortune 500 company building and staffing an international internal security department, focusing on internal affairs and insider threat. And then after 10 years, retired from that position and started my company as a private investigator.
Who was the special agent in charge in Atlanta when you retired?
When I retired, it was, wow, it was Bill Hinshaw, then he was the last one I personally knew. I don't recall the name of the special agent in charge because with the FBI, you rarely interact with the special agent. They're like the king.
It's bad news if you're interacting.
Yes, sir, especially when you're in a small resident agency in Brunswick, Georgia for all those years.
Okay.
At my request, did you review the state evidence relating to the firearms and ballistic evidence?
Yes, sir, I did.
Without necessarily detailing piece by piece, can you tell us what did you review?
Yes, sir. I reviewed the reports and the photographs that were tendered and compared them to my experience in having worked a number of cases that were violent and similar in nature that involved reports like this and testimony on this topic, and had a number of questions about them.
By that then, did you also review the testimony?
Yes, sir, I did.
Okay. And again, without going through all of the names, did you try to, or did you review all of the possible state witnesses in that area?
Yes, sir, I did.
And I believe that would be Sarah Cheek, Detective Patterson, Peter McFarland, Allison Vance, Christopher Robinson. Those names sound familiar as
Yes, sir,
testimony
they
you looked
did.
at? Okay.
Yes, sir.
Did you also look at exhibits?
Yes, sir, I did.
And that again would have been exhibits that were introduced at trial?
That is correct.
And did you look at anything that was not introduced at trial? You mentioned reports, stuff like that.
No, sir, I believe this was all evidence that was part of the original trial.
Okay. And you did this as an investigator, not per se as an expert witness.
Correct. Having testified at countless hearings, grand juries, and trials, summary witness testimony is something that I specialize in now, and it involves reviewing materials such as this and based on my experience offering commentary without offering expert opinion.
Okay. And what, if anything, can you tell the court?
There were a number of photographs that were used with testimony involving dowel rods, which were intended to show trajectories of bullets that were of particular interest to me. I made a number of assessments based on reviewing that testimony and those photographs, as well as evidence recovery from the crime scene, which was focused on the BMW automobile, which was critical to this incident, and the DNA test results from blood spatters recovered on the exterior of the vehicle as well as the interior of the vehicle. And then lastly, some of the casings that were recovered from rounds that were expended during this incident.
Not looking for speculation, but what can you tell us from your review of the reports, the exhibits, the testimony?
Your Honor, can I ask you for a clarification? I believe he testified that he interviewed a number of people who had been involved before. And so,
That was vague to me, whether it was interviewed or I read their testimony. So this is all being taken from the record as opposed to extra record.
Yes, sir. Your Honor, my apologies if I used the word interview. I didn't interview these folks. I reviewed their transcript material.
Okay.
Sure.
I'm sorry, go ahead. What did you determine? What did you find out again without, I don't want your speculation.
Right. So starting with the photographs that were entered into the record, and with the dowel rod, I brought them with me if it helps. I don't know, but it was clear that the review of the photographs and the testimony regarding the trajectory of bullets, along with other transcript entries that showed people were proned out during the event, that they were extracted from the vehicle, forced to lie down outside the vehicle prior to the gun shots being fired.
You're talking about the victim and Ms. Blaylock?
Yes, yes. It's clear that the photographs and the dowel rod trajectory demonstration supports that the victim was prone or in a very low position when expending the rounds that impacted the BMW, both in the door, through the canopy, it was a convertible, and through the front windshield. It also supports some of the story that was provided by Mr. Waters during his testimony and subsequent interview with me. And
Objection, Your Honor, as to hearsay from Mr. Waters.
Sure, so let's focus on what his testimony at trial reflects and not what he may have told you.
yes, Your Honor. Yes, Your Honor. It supports the placement of the victims and the expenditure of the rounds that impacted the vehicle, and one of the rounds that impacted Mr. Singleton as he was fleeing the automobile. Also, the recovery of blood spatter evidence from the interior of the vehicle and the placement of the victim's blood on the exterior and interior of the driver's side door, and the smear from Mr. Singleton that was identified exiting the door or smeared off the passenger door during the testimony.
So long story short, what does that tell us as far as the positioning, if you can tell from what you review, of the victim, Mr. Waters, and Mr. Singleton?
It looks like it supports the testimony of Mr. Waters and the story of Mr. Singleton, in that the victims were removed from the car prior to any gunshots being fired. The gunfight ensues with the victim firing into the vehicle, gunshots being returned that struck the victim in the upper shoulder, which shows a low, a gunshot from high impacting low, and the blood from Mr. Singleton on the passenger door smeared during an escape attempt.
So that then would show that Mr. Singleton was exiting the vehicle through the passenger door.
It would support that, yes, sir.
Does it show you where Mr. Waters would have been at that time?
It's difficult, and I'm not trying to make a conclusion or offer an opinion, but it supports a story that Mr. Waters was initially outside the vehicle or initially inside the vehicle, but fired rounds from both positions. The placement of the shell casings on the floorboard of the passenger side would support the pattern you would expect from firing inside a vehicle, where a Glock weapon, which was the weapon used in this case, extracts the vehicles up and to the right. They would land in the passenger side and find their way to the floor. Additionally, Glock shell casings on the exterior of the car would support Mr. Waters' testimony that he was outside firing over the hood at a proned out victim when that took place.
And Sergeant Grigley did not have a Glock.
That is correct.
Is
He
what
had
you
a
think the
revolver.
evidence shows.
The evidence shows he had a revolver, and that.
So there'd be no shell casings from his firearm.
Yes, sir. Yes, Your Honor, you're correct.
The reference volume 4, page 951, the state argued the forensic evidence showed Leslie was shot inside the driver's side of the vehicle, not the passenger side, and this showed Waters was telling the truth. That sounds like that's contrary to what you see from this.
I would dispute that vigorously, because if someone, hypothetically, if someone is struck with gunfire on the driver's side or in the driver's seat, there would be blood evidence at that location, not the way it was presented in court, where this victim, Mr. Singleton's blood, was smeared on the, I think it was the lower door panel of the passenger door, not extracted anywhere or recovered anywhere on the driver's side or anywhere on that side of the vehicle.
Now, this is something you were able to see as an investigator.
Yes, sir, that is correct.
Is it something that an investigator should have looked at, could have looked at, would have seen?
I think that and it's difficult to say this without sounding critical, but I think it's readily apparent even to what would likely be a layperson, let alone somebody with experience in law enforcement and investigating crimes, that there is reasonable doubt, there's question about the state's testimony conclusively on the placement of Mr. Singleton at the time of this event and how that sequence of events transpired.
We've talked before that Mr. Gishard did not cross-examine Sarah Cheek, Patterson, McFarland, Vance, Robinson, and I referenced volume 2, 444-503, and volume 3, 742-753. Does your investigation support that there would be questions that you could ask those witnesses on cross-examination?
So my experience in having the span of time that I spent as an agent and even now as an investigator, I've worked closely on cases with prosecuting counsel and, in the civil arena. That extends to preparing a case, participating at counsel table during the contest, and to provide, input back and forth, as has even been done in this case from counsel table. The lack of a choice to cross-examine a witness of this type at this type of a profile case can often be satisfied by presenting rebuttal witnesses, expert witnesses. Neither was done in this case, and I found that highly questionable, given my experience, that no cross-examination took place to establish reasonable doubt, and no subsequent rebuttal witnesses were presented to establish reasonable doubt in this area.
What can you tell us about your efforts to do an investigation collectively this 22, 23 years later?
I found it to be terribly.
When you say investigation of what?
The Singleton case, trying to locate witnesses, locate documents.
Okay, I mean, I knew it was of this case, but it's not recreate the crime scene,
No.
find the BMW, look at the blood on the door. I guess
I'm sorry.
That's okay. I didn't need to understand what was contemplated by investigation now, 22 years later.
And again, going in, you knew from the get-go that Mr. Gishard had passed away.
Yes, sir.
Tell us about your efforts so far as trying to determine what happened, what evidence is available today, things of that nature.
So my investigation in this case, started out rather specifically with, the receipt of a letter that was sent to the Department of Corrections, which I think initiated this entire effort. It began with identifying who Mr. Waters was and doing that interview. But beyond that, the investigation began to kind of fan out into attempts to retrieve court transcripts, juvenile court transcripts, any type of relevant data that would have been presented or should have been presented in the Clayton County case or the Fulton County case. And part of that was to identify and interview counsel that had participated in the defense of the case and the subsequent appellate phase, as well as other former defendants or complainants who had similar experiences or were related to this case via their law enforcement experience.
Did Mr. Singleton, and this isn't necessarily a question for you, it could be any of the three, have his Clayton County case was a trial?
Yes.
And he was found guilty and he got a sentence. Did that appeal go through, or is that also?
That appeal went through and there's a reported decision.
Okay, affirming the conviction.
Yes, sir.
They're
Okay.
still waiting for and I forget how it works in Georgia with the habeas corpus, whatever's after the appeal.
That'd be habeas corpus,
That has
but
not
there's
yet been
4
decided.
years from the date that the conviction becomes final, meaning exhausting the direct appeals. We're still in that window or there was a habeas filed or
Fair.
TBD?
There are some courts that don't act responsively as this court.
Okay,
It was timely filed, it's sitting there.
okay. But there was at least a motion for new trial and direct review of the conviction and sentence out of Clayton County.
Yes, and I will give you I can give you the citation if you would like it.
I would. Was it a reported decision?
Yes, it was.
Great.
326, Georgia Appeals, 609.
All right, thank you.
2014 decision.
Okay. Sorry for that diversion. You were mentioning that one of the things you did was try to get records from the Clayton County proceedings, and I was worried you were having to dredge up old files and no appeal, et cetera. Different situation.
And Your Honor, I do have a transcript from the sentencing of Mr. Singleton, page 174, that I would like to offer into evidence. Give a copy to Mr. Armstrong.
The same objection I'll have before. A certified copy of the transcript would be what's appropriate and would also be more complete.
What you have is just a few pages from the sentencing transcript, or it's the final disposition?
It's the court saying, I'll show you the same leniency you did that police officer.
Okay, so you know what Mr. Armstrong is going to be objecting going forward. If we can just admit next time, just admit the whole transcript. Here, it's 7,000 pages, but for the sentencing, it's going to be 20 pages or whatever it is. Here is the sentencing transcript, and you're free to highlight whatever portions you want, to include the judge being frustrated with Mr. Singleton about not showing leniency to a police officer. But just the 2 pages, if you've experienced how difficult it is to get records, it's sometimes just as difficult for the awesome power of the state. So if you've got it, maybe through the grace of Mr. Singleton's family, sharing that will save us some objections.
But his latest request is that it be a certified copy.
That is the appropriate way to get it. Courts will typically certify documents.
I understand the difference. I see your point. This wasn't a Rule 106 issue. This isn't even certified. But for purposes of this hearing, is this N, or what letter is this?
Good question.
You had a different N, I believe.
So let's not make it N.
It's
Am I
going
wrong?
almost all the way to the end of the alphabet as far as possible states. So far as the ones that have been introduced, almost the last one. So if you want to go in that direction.
I want whatever letter you want to give it.
Then I would say X.
X. Okay. X.
So I'm sorry, you are receiving it, or you want to wait?
I am.
Yep, so tags I can mark, or is the correct? And again, I am still certainly willing to give the court all the transcripts, but again, I don't have a certified. And unfortunately, coming from the victim's family, my memory is that there'd be highlights here and there.
Wow, things worked differently there back then. Oh, okay.
Okay, if I may continue.
Please.
I'm sorry, I didn't mean to interrupt you. If we interrupted you about your experience or what you found, what you didn't find, just trying to do your.
So I basically having, kind of summarized the span of individuals and content of materials I was looking for, found that with the passage of time, and certainly with no pun intended, with the passage of some of these folks, it was exceptionally difficult to get anything meaningful for this case. We expanded that search, which included attempts to surveil and serve subpoenas on personnel as far out as Chicago, Illinois, which were similarly unfruitful.
What about so far as court files?
The court files were very difficult, as this court has experienced in recovering and examining.
And my memory is you had no success getting the county clerk file or the juvenile court file.
That's correct. I guess I was just being overly polite.
The Chicago, that was Mr. Gouchard's relative.
Yes, sir, that's correct. We were able to, as we do with any exercise to locate and interview a witness, ran a number of different due diligence reports. We're able to generally locate the last known address and then dispatch personnel to that location to wait, identify and interview and serve. But none of those were successful.
With the court's ruling, I'm not going to go into any type of details, but you did at my request try to locate similarly situated defendants, persons that had filed grievances, witnesses in similar cases.
Yes, sir, that is correct.
And more times than not, without any success.
Almost universally without success.
And you also followed through on the Department of Juvenile Justice assessment.
Yes, so I spoke to one lady that was connected with this, had passed away. The other gentleman, Mr. Vignati, I spoke with. He put me in touch with their general counsel. General counsel, when I interviewed her, said that they absolutely did not maintain those records and they did not have them.
One of the issues that we've talked about is hearings in the juvenile court or even in the superior court or with the magistrate. Did you try to get Metro records as to when Leslie would have been transported back then?
Yes, sir, I did. I made those attempts and was unable to retrieve those as well.
And again, without going into too much detail, you also looked into Clayton County.
Yes, sir, I did.
What did you do there?
I interviewed the officers and reviewed internal affairs reports dealing, centering on the robbery or the origin of this weapon that was ultimately used in the homicide, and spoke to officers that were connected with that case.
Are those things that would have been worthwhile looking at before Mr. Singleton's trial, either by Mr. Gouchard or by the investigator?
Yes, sir. And by worthwhile, I think there's an obligation to do it, and you take the results as they come.
And part of that being as to what actually happened when Leslie ended up with this book bag.
Yes, sir, that's correct.
And then part of also is the what and why so far as Officer Poplis.
Yes, sir. So the weapon that was ultimately used in this crime was assigned to Officer Poplis, and Officer Poplis gave a number of interviews to Internal Affairs, some of which were under Miranda warnings. And I was able to speak to Mr. Poplis, who has since left police work, a number of times. And there were probably at least 5 or 6 different versions of this event. And it was, concerning. And it was something that.
Objection, Your Honor, best evidence rule about the different interviews and things like that.
Okay, and it sounds like you're referring to things he told you now as opposed to what you learned by reviewing. It's both. You reviewed records that showed he gave different statements, but it also, what I was hearing was, I found Poplis and he gave me different versions as well. Again, hearsay if you're sharing with us what you were told by someone in the course of the work you were doing on behalf of Mr. Singleton.
Yes, sir. Yes, Your Honor, understood. But certainly the review of the documents that were on file demonstrated significantly different versions.
Objection again, we're talking about records that are not in this case.
And if it does come in under 404, so far as his character or trait of character or other bad acts.
Okay, well, we're getting a little far. Did Poplis testify in the Fulton County trial?
He did not.
Okay, so then let's move to a different topic. I'm getting it that Poplis had different versions of events.
Okay. And again, it's something that should have been looked at by Mr. Gashari or an investigator before the trial.
Yes, sir, I would say so.
Did you ever, were you able to talk to Officer Bell?
Yes, sir, I did.
What can you
Help
tell
me know understand what Officer Bell's connection to the Fulton case is, not the Clayton case.
I also have an objection to hearsay based on the question.
Okay, first let me know who Officer Bell is in connection with the Fulton case.
Officer Bell had provided information about the origin of this weapon and how this task force officer he's essentially the one that pointed to the questionable events that led to this weapon being in their possession and ultimately being used in this crime.
Bell is the one who got that rolling.
Yes, sir.
Okay, now ask your question again and I'll assess it for hearsay, now that I know who he is.
That's the answer that I would have asked.
That's the answer you were looking for?
I would have asked.
Okay,
Tell us
well,
about your.
it's in.
And again, even Officer Bell, that would have been worth looking into by Gashard or his investigator.
Yes, sir. And so basically
I'm sorry, I thought that Officer Bell testified at the trial.
At the Fulton County?
Yeah.
I don't think he did.
I don't know who Officer.
Oh,
Bell is.
okay. I thought that's why we were talking about Officer Bell. Let's stop talking about the gun insofar as talking to people who did not testify in Fulton County.
Okay. Long story short, then, what happened in Clayton County would have been something worthy of investigation in the Fulton County case before the trial.
yes, sir. So you have an event that happened, a tragic event where an off-duty officer loses his life during a criminal incident. The weapon, ballistics, trajectories, DNA, all of that starts at that crime scene, and then in an investigation to provide a full and robust defense, you would go backward to find all the details that led to that event, which would include, I'm sorry.
No, you keep going. I interrupt.
Which would include how this weapon came to be possessed and ultimately used in this crime.
Remind me, was the Officer Poplis's Glock left at the scene or handed over by a defendant, or how do we even know that Officer, I'm gonna let the state answer, that we know that Officer Poplis's gun was what I'm gonna call the murder weapon?
After it was robbed from Officer Poplis in Clayton County, Leslie Singleton had it, showed it to other people, said he'd gotten it in multiple ways, including nefarious ways.
I'm sorry,
He gave
I
it to
object to
Michael
Mr.
Waters.
Armstrong testifying. This is not true what he's saying.
Okay, you're gonna be able to give your, I just wanna know how ultimately it was connected with the case.
He admits that he gave it to Mr. Waters as they were walking away from the apartment on that night. Mr. Waters used it to shoot Sergeant Wrigley. He then, he being Mr. Waters, hides it that night in the bushes and then goes back and turns it over to a friend named Jackie Brown.
Jackie Brown.
Just like the movie.
Okay.
And he ultimately tells officers about that. The officers go to Jackie Brown's house. They find this gun that is distinctively marked Fulton County Sheriff's Office.
Okay.
And they do ballistics testing and confirm that that is the murder.
Got it. So it's Waters in a statement to the police saying, here's how I disposed of the gun. And they're able to corroborate it because lo and behold, Jackie Brown has that gun.
Right.
Okay. Mr. Hort, don't get wrapped around the axle about how it got to Waters. I just want to know how it was recovered.
Okay.
That's all I wanted to work
Well,
through.
then I would ask the court to disregard the other portions because it is not true.
Well, I'll filter it the way I've been filtering things that you say, that Mr. Armstrong jumps up and says that's not true either. I'll be guided, of course, by the record that was made
Please.
at trial,
And
which I'm
that's-
sure shows that they got the gun from law enforcement got it from Jackie Brown after Mr. Waters said, oh, I put it in the bush, and I got it out, give it to Jackie Brown. That just closes the loop for me. In fact, the gun was recovered. And so we're not guessing that it was Poplis's gun. We know it was Poplis's gun.
And that should have been the answer to you. It was not bang, bang, bang. It was.
Okay, but you know what? Pot Neat kettle. Next question.
Okay. What did you find out in your investigation so far as Officer Populous' character or trait of character or other bad acts?
So he didn't testify in Fulton County?
But that's part of our complaint, is that Gashard should have done something, maybe not call him as a witness, but bring in all these witnesses to show that it's not as how Mr. Armstrong is telling you today.
I get it. Okay. So, but you've established that, and I think investigator Alec did as well, is that you have a situation, two guns, ballistics, this and that, and then you push back in time. Where did the guns come from? And one was, of course, Sergeant Grigley's lawfully possessed and carried revolver that he used to defend himself and the woman he was with. And the other was this gun that ultimately could be sourced to, it sounds like it would be Deputy Populous, but either way.
What I was trying to bring out is that Populous had his post-certification revoked, that he was suspended from an incident in 2002, financial wrongful dealings with he and his wife, all these type of collateral things, again, that should have been investigated before the trial that my investigator found out 20, 22, 23 years later.
Okay. And they're all things that occurred before this incident, not that 10 years ago, Populous did X and 9 years ago, he did Y.
I think most of it happened afterwards, because when this happened, he was still a police officer.
Okay.
So all of the revocation came post-trial.
Okay.
Okay, let's talk about Mr. Waters. You interviewed Mr. Waters in prison,
Yes, sir, that's correct.
okay? And by that, you obtained the affidavit, which we have marked as Exhibit C, and also discussed with him the letter that he wrote, which is marked as Exhibit B.
Yes, sir, that's correct.
One of the questions raised way back when was the validity of that affidavit, whether you forged something or did something improper. What can you tell us in that sense about the affidavit?
So having interviewed witnesses, subjects, defendants, I don't know how many times over 30 years, there is a process. I made the appointment with the prison, excuse me, where Mr. Waters is an inmate. I got processed through their requirements to be an authorized visitor. I made the arrangements and traveled to the Burris Correctional Institution in Forsyth, Georgia. Met with inmate Waters. Went through the process of identifying myself, the purpose for my visit. He made it clear the voluntariness of his participation in that interview. I provided him a form that I use for my business, which makes it clear that, you know, it's a voluntary interview and they can stop at any time. And then we had a lengthy visit where he provided sincere answers to my questions. At the conclusion, he asked me to.
Objection, Your Honor, hearsay.
So
I'll just go through the process.
there you go.
Got it, sorry.
Well, I guess if he had a question is not a statement. So you can tell me if he had a question, what that is. I'll overrule it if he said, "What's the weather like?" Or something, as opposed to an assertion. "It's cold in here. I didn't like talking with you," whatever he may have said.
He made a request of me to prepare a statement to document what he had provided during the interview, to express his remorse, and to capture his statements against interest, which I did. With the computer that was provided by the correctional institution, I typed it up, presented it to Mr. Waters. He read the statement. I asked him to pay particular attention to the details and to make any edits he wished to make so that it was fully accurate. He did that. He initialed those changes. He initialed the top, signed the bottom of every page, which is standard practice I use in gathering statements. And then he signed it, and I provided it to you.
Showing you what is marked as defendants exhibit C and B. Is C a fair and accurate copy of the affidavit which you have mentioned?
Yes, sir, it is.
And that also includes, I believe, some type of advice of rights to him.
Yes, sir. That's the information page I just referred to, where they make it clear that they understand what they're doing, they understand why I'm doing it, and they're, volunteering to participate in.
And exhibit B, defendants exhibit B.
Exhibit B is the copy of a letter that was purported to be written by Mr. Waters to the Department of Corrections, recanting in part.
Objection, Your Honor. Here's that.
It's not offered for the truth of the matter asserted at this point.
It's being offered with the truth of the matter, sir.
We have not offered it as an exhibit yet.
Okay,
Having testified about what's in it is still.
so don't talk about what's in it then.
Okay.
So B is what you understand to be a letter from Waters to GDC. not
Yes,
to you.
yes, Your Honor, that's
Okay.
correct.
And did he acknowledge that was that letter?
Yes, he did.
Now, did you also then serve him with a subpoena?
Yes, I did.
Do you remember when it was that you had this first conversation with him?
I remember
It's not dated on the affidavit.
it was April 8th. It was Eclipse Day, and I remember totaling my truck on the way back from that interview.
Because of the eclipse?
I wasn't looking at the eclipse, but the other driver may have been.
Oh,
Glad you're okay.
Thank you.
I'm guessing you did not include that in your request for reimbursement.
No, sir, but now that I have the idea,
So was this somewhat early in your work for me as an investigator?
yes, sir, I would say that this was one of the first, if not one of the first, the first step in my effort.
So obviously you have learned or found out many things post meeting with Mr. Waters.
Yes, sir, that would be fair.
Now, did you recently talk to Mr. Waters about testifying here in court today?
I did. Yes, sir.
And fair to say that he is refusing to testify?
He refused to testify, and when he refused to testify, I'm not going to say it. He just said he was done with it.
Your Honor, you had earlier asked to explore this when we first went on the record this morning. So I don't know if you want to do that now or you want to.
It was more curiosity. I mean, he said what he said, and that's hearsay, and if there's an objection to that, then it shouldn't come in. It just represented a little bit of a volte-face because you had previewed that he'd be testifying because you thought he would, and then he wasn't. But I also appreciate the ebb and flow of life as an inmate. I mean, not from personal experience, but from professional experience.
What can you tell us, the first time, second time, demeanor, attitude, reaction to you talking to him?
Objection, relevance to his demeanor when this witness was talking to him.
What is the relevance? Clearly something changed in his heart. He's not here. And we're not able to get into that as best I can tell. So how is it relevant if he was open and forthcoming in visit 1 and closed and distant in visit 2, or the reverse?
I guess I base it on many times what I saw as a judge, standard questions. Okay, describe his demeanor.
The objection wasn't that it's hearsay or anything like that. I think witness is competent to do that. The objection was relevance. What's the relevance of what his demeanor was like?
Well,
Contrasting between the 2 visits.
again, going back to my memory as a judge, when you're talking to someone, if they won't even have eye contact with you, if their face gets all red, or if they say things that somehow spark your curiosity, those type of demeanor type of questions are important when you talk to a person.
Okay, but you're not asking me to assess the credibility of Mr. Waters. He's not testifying, so it's not being used to impeach or bolster him. He has made himself unavailable. And so I don't understand how it's relevant whether he was friendly one time and distant the other. He clearly had a change of heart. And he may well have said, here's why, but what he told investigator Alec, we can't get into here. We did hear that he's just done.
My next line of questioning is then going to be to admit defense exhibits C and B, the letter and the affidavit.
Okay.
Objective hearsay.
To C and B?
The letter and the
Both of them
affidavit.
is hearsay, and I would also object to them on relevance grounds for OCGA 5523, which is a statement that's impeaching of a testifying witness is not the basis for a motion for new trial. But couldn't they offer a new statement? That's not a basis unless other things are shown. And also, the affidavit is pure hearsay. I can't cross him, and so the objection is that it's hearsay.
Okay.
And I would counter that it's submission by a party opponent. Obviously,
What's the counter?
This is not State versus Mike Waters, this is State versus Leslie Singleton.
Okay.
And he is not a party opponent to a co-defendant. Mr. Singleton is not.
No, you're right. And there's not a conspiracy anymore, so it's not a co-conspirator's ongoing statement that might come in. How about this? I will not take B and C. You should hold on to B and C. And we don't need to have investigator Alec take the stand again. I will let you think about it a little bit. And when I say brief it, it's as simple as sending an email with 2 or 3 cases. Or whatever. I don't mean for this to be 10 pages single spaced. But I don't want to get it wrong on whether those come in or not. But right now it does seem like it's hearsay because Mr. Waters has decided to make himself unavailable. So there's not a way for the state to say, when you said this, what do you mean by that? How do you explain this statement as contrasted to what you said under oath in trial? So 2
points, if I may. One is demeanor. I certainly see that I piqued your curiosity when I said the admission by a party opponent. And 2, Mr. Armstrong has had these statements for months. If he wanted to interview Mr. Waters, he certainly could have.
So interviewing is different from cross-examining under oath. Mr. Waters might have given Mr. Armstrong a different reception than Mr. Alec.
And he could call him as a witness.
He could try.
Yeah.
So
anyway, I appreciate the court's offer.
All right.
Okay, that might just about wrap it up, and let me quick look. Thank you.
Mr. Armstrong, any questions for Mr. Alec?
Do you have a different title than Mr. at this point in time?
No, now it is simply Mr.
Okay.
Thank you for asking.
I asked that question for anybody who's ever been a special agent. Going over your testimony, you said that the evidence supports Waters' trial testimony. Is that correct?
Yes, sir, I did.
And it supported the other witness's trial testimony. Is that correct?
I don't know that I reviewed too many other witnesses' testimony, so I don't know if some conflicted with it, but of the ones I reviewed, yes, I would say so.
Okay. Whose testimony do you recall reviewing?
I recall reviewing Mr. Singleton's, Mr. Waters, and I believe that was the extent of it.
Okay. You testified that it was unlikely that Mr. Singleton would be in the driver's seat
at the time he was shot because there was a smear on the passenger side door. Did I get that correctly?
Yes, sir, that's correct.
This wasn't mist. This was a smear, correct? This wasn't splatter. It was a smear.
It looked like a smear, yes, sir.
Meaning that that's where a human being applied physical force with a bloody part of their body on the way out.
Yes, sir, that's correct.
How does that determine whether they were in the driver's seat or the passenger seat when they got the blood that they later touched against that bottom side of the door?
So at risk of testifying like an expert, which I'm not intending to do, when you're shot, there is an impact and there is blood. And there would be either blood on the door, steering wheel, console, or seat if you're shot in the driver's seat.
But if he got shot and it went in his shoulder and he's wearing a jacket and a shirt, there might not be spatter anywhere, and it takes a while for the blood to course down his arm, and he is realizing, I can't get out the driver's side because there's something over there that I don't want to get into, so I'm going to try to get out the passenger side, and I extend my arm and there's blood coming off it, and I'm not making that up. I don't know the facts of where he was shot and whatnot, but they don't strike me as mutually exclusive, that he could be in the driver's seat, get shot while he's in the driver's seat, but the blood of his that is findable, not trace amounts, but visible, testable amounts, would be on whatever surface he touched as he tried to get the heck out of that car, which could well be, yes, I'm crawling over the emergency brake, but my way out is the passenger way, and I'm gonna do that.
And Your Honor's explanation is worthy, but that is what, as an investigator, we would want to present as reasonable doubt. And it's that very absence of that presentation of reasonable doubt through cross-examination or presentation of another witness that I'm referring to here.
Okay. And you did testify about the importance of your testimony as possibly creating reasonable doubt as to that testimony, was I believe the quote that I wrote down.
Yes, sir.
What testimony were you referring to as being reasonable doubt towards?
So I was referring collectively to the testimony of the crime scene expert, the DNA reports, and Special Agent McFarland's demonstration of trajectory and, the recovery of evidence at the scene. I'm generally referring to that as a collective, that the cross-examination of any or all of those witnesses and or the presentation of other witnesses to rebut that would have been aimed toward creating reasonable doubt.
Okay. You understand that reasonable doubt is an issue about culpability, correct?
Yes, sir.
Okay. What is the difference in culpability in your assessment from this case between whether the moment of impact occurred when he was in the driver's seat, which he admitted he was seated in, or the passenger seat?
Yes, sir. So to kind of put a fine point on it, the story about fleeing and abandoning the criminal enterprise and escaping prior to the shots being fired, which I think was some of the testimony or transcript that I read from Mr. Waters, that this took place. The evidence would seem to support that from a reasonable doubt standpoint, that Mr. Singleton was opting out or, actively extracting himself from the scene prior to what eventually was, a tragic result.
Okay. Do you agree that the blood smear shows that Mr. Singleton was in fact in the car at the time he was shot?
Yes, sir, I would say so.
So there's no question about the state's case that Mr. Singleton was in Sergeant Grigley's car at the moment he was shot by Sergeant Grigley?
I think that's clear, yes, sir.
Okay. You mentioned difficulty trying to get the clerk's file. Were you referring to the clerk of the Superior Court of Fulton County?
At this point, it seems to be that every clerk, I did have difficulty with the clerk of Fulton County and also with the juvenile court. So I was, had similar difficulty at both phases.
Do you have access to something called Odyssey Case Manager?
No, sir, I do not.
Okay. Are you familiar with that program?
Generally so, yes.
Okay. No further questions. My points will be made in argument rather than cross.
Okay. Mr. Hort, anything else from Mr. Allen?
Yes, thank you, Your Honor. If you can, you were asked on cross-examination about your review of the forensic and ballistic evidence supporting Mr. Waters' testimony. Do you remember or recall what portions of Mr. Waters' testimony it would have supported?
Not specifically, but there were portions where he referred to being outside the car, shooting over the hood of the car, which seems to be supported by some of the shell casing placement that was provided during the trial, as well as, the placement of the individuals, including Mr. Singleton being in a flight at the time that the shooting started.
So nothing inconsistent with the defense theory of the case involving abandonment?
No, sir. In fact, I found it to be consistent.
And did you know that Mr. Singleton was wearing a University of Michigan shirt?
No, sir, I did not.
Not a jacket or coat or anything?
No, sir, I was unaware.
Okay. Would that kind of indicate to you that it's very possible than it did as you interpreted initially?
I think, the lack of bulk, in clothing would lend itself to what I was saying earlier, that, if impacted by a round, you would leave a blood trace.
At any rate, worth investigating.
Certainly worth investigating.
Thank you.
All right. Thank you, investigator. Appreciate your time.
Thank you, Your Honor.
All right, we will take a brief break because I believe next up is Mr. Singleton.
Yes.
All right. Mr. Singleton, can you unmute for a second so we can see what the volume is like there?
Yes, sir.
That's good. We're going to take about a 5-minute break, and when we get back, it sounds like Mr. Hort is going to call you to testify. So if you need a break, I don't know how restrooms work, that interview room and everything, now's the time to do it, and then we'll be right back on, okay?
All right, thank you.
Okay.
5 minutes, John?
Yep. 5-ish.
5-ish.
I know, man.
Yeah. Judge gets
I swore at the court when I got sworn in.
I know.
He's gonna read the search warrant.
Okay.
Don't have any idea what these are for.
I was wondering, I don't know whether that's a sickness goal or gotta bring snacks.
I've not ever noticed that before.
I was hoping it was for snacks. I was thinking like.
Well, apparently we're not high on the list of people to give snacks to.
Peanuts or pretzels or something.
I have seen it every now and then in a courtroom. Makes sense. Back in the olden days, it was probably just spitting. It was chewing your tobacco.
Yeah, that would be so nasty.
Sometimes your client doesn't get lunch. So you.
Let's see, for high sub, I guess there's a time they're gonna cut them off. Because they have the microphones on.
I was gonna bring that up with the judge.
Detective Dwyer,
Yes, sir.
if you come on up here,
Detective Phillips comes with me.
that is fine, he can come too. He looks more official than you with all the tactical gear on. Only question I had in this, and it probably just was a hangover from something else. This is all about this, but that's right there. I assume
Yeah.
there was no evidence of anything, so you might want to cross that out, write burglary and initial it. And then it'll all. Excellent. Okay. And I'm not an expert in what language you need to use to give to T-Mobile to say this is forward going, because this is a little different. Usually you guys want to get the cell site information from the night before or whatever it is, and you're trying to grab this guy. So I'm assuming someone in your law department or from the DA's office has said this language gets it to you real time. It's what you asked for, but you don't think T-Mobile is going to balk at this language.
So I used to be on this unit, the fugitive stuff, and
Yeah.
I've used this warrant probably, I don't know how many times before. And
All right,
they've
it
always
works.
gone through.
Good.
So-
Hey, don't mess with it.
All with T-Mobile. So.
Okay. All right. Good, good. All right. Do you swear affirm that the contents of your very long affidavit, true and correct to the best of your belief and knowledge?
I do.
All right. Do you guys know this guy? Like, it sounds like Bice recognizes him now just by seeing him in the, is he a familiar guy?
Yeah. He's the lead fugitive detective on it, and he's haunting his dreams at this point.
And we still think it's a good phone number?
Yes.
All right. Good. All right, so there's the warrant part. And you sign there. Click back.
There's a court order. There's an order at the bottom of that too.
In here?
At the very bottom.
Oh, that's what this fancy colorful thing, oh, this tells them
That's
to don't disclose.
Correct.
Okay. I've seen that before.
It's more of a precaution than
Yep.
anything else.
Better safe than sorry.
Thank
Good
you,
luck.
sir.
Be safe.
Thanks. Appreciate
All right.
it.
Let's get back on the record first. Make sure Ms. Rivers is good to go. Ms. Rivers, you ready? Great.
Yes,
All right,
Judge,
we're
I'm
back
ready.
on the record in State versus Singleton. Mr. Singleton is ready at Coffee Correctional, but before we let Mr. Hort call him as a witness, Mr. Armstrong.
the defense mentioned this during the break, but also earlier you mentioned that there might be a cutoff time for Coffee Correctional. And so I just wanted to inquire if they had a cutoff time anytime soon.
I don't know. Our cutoff time is 5. That's when we'll be stopping. We may have to end earlier if coffee closes earlier than that. Mr. Singleton, 1, you're gonna need to get unmuted by someone because you're up now. 2, have they given you a sense of how long you can sit there?
No, I haven't. I'm sure that this shift goes home at a certain time, but 4 o'clock is count time. I can be here during count. So between.
Well, we're gonna use the time that we've got, and if it has to end early because of GDC requirements, we know what's left, and that's getting Mr. Singleton back. Because it's through Zoom, that's less hard. That is easier to schedule than if we had to produce. Okay. Mr. Hort, you ready?
Oh, my concern is I don't see any way possible we're gonna be done with this testimony by 5.
No, I wasn't trying to cabinet or wedge it in there. If you don't want to use this time, if you have a realistic estimate of how long your direct exam would be, we could try to do all of that on another day. I'm not trying to chop it up. I just want to use the hour that we've got. I defer to you.
Okay.
It's been a long day. You may be done.
Well, and we also have a few things we need to discuss from Ms. Wardell's testimony that we decided to wait until she was off the witness stand.
Okay.
Can I talk to Mr. Lee a minute?
Sure.
Thank you, Your Honor. I know Mr. Singleton would like to get it done today, but I just don't see that that's going to happen, again, through no fault of anyone. And my preference would be that we do all of his testimony at once.
Okay. What is your best estimate as to how long your examination will go so that we try to block out a sufficient window?
I think mine will probably be an hour and a half.
Okay. So it seems like if we blocked out half a day somewhere, we'd be building more than a sufficient cushion for direct, cross, redirect, and get all that in.
Yes.
Okay. We can make that happen. Don't go anywhere, Mr. Singleton, because there's other stuff we need to talk about, but you are welcome to mute again in case there's background noise at coffee. And I'm happy to hear, Mr. Hort, if there are other things you want to talk about before we wrap up today.
Okay, thank you. In Ms. Wardell's testimony, there were a number of issues that I was going to explore. Mr. Armstrong.
Right, you're going to make some comments.
Right.
Okay.
And so I'm going to that at this point. First one involved the State versus Michael Lewis, S04A2006-279 Georgia 69, decided by the appellate courts in 2005. Ms. Wardell was the second chair also in the Michael Lewis case, and it's my understanding from her that it took place, my best guess is shortly before Mr. Singleton's case, but right in this time frame. Our offer of proof is that Mr. Lewis was a juvenile African-American, poor with a troubled family, convicted and sentenced to life in prison as a juvenile for malice murder. His defense was that older relatives had set him up for the fall, thinking the law would not come down hard on a child. He was sentenced as a juvenile to life in prison and denied parole in 2011, 2016, 2020. I expect Ms. Wardell would testify that she spent the most time by far with Mr. Lewis, but juvenile psychosocial issues were not brought up at his trial. She recalls that Mr. Gishard got all the facts of the case from the investigator, specifically that Mr. Lewis had confessed in the presence of his probation officer. And at that point, Mr. Gishard's attitude changed. He said, I'm not going to spend the entire month of October preparing for a trial in this case if his probation officer is going to testify to this. He scaled way back after that. Gary hated to lose, and he didn't work hard in the cases that we knew we would lose. And also, I expect that her testimony would be that a friend whom he said that there was an alibi defense, that a friend whom he says he had been riding bikes with when the crime happened, the witness was sent home by Gishard. So we were bringing out the Lewis case for two reasons. One, because it's the same time frame, and two, because of the similarities in the Lewis case and that in the Singleton case. I can keep going if you want to first hear from Mr. Waters on that one, or,
From Mr. Armstrong?
no, I'm sorry, Mr. Armstrong.
Nope, I'm good.
Okay, so then with regards to Mr. Greenberg, the office closed in December of 2004. He apparently kept Mr. Singleton's case as well as others. And what I was going to bring out that, and ask the court to take judicial notice, that in the State versus Marcus Burke, Fulton Superior Court case number 00SC09016, Gashard and Greenberg are listed as defendant's attorneys. The charges included voluntary manslaughter, possession of a firearm during the commission of a felony. On November 4, 2004, defendant was convicted. On December 6, 2004, a motion for a new trial was filed. The court file includes a letter from defendant on February 8, 2011 and April 11, 2011. Online Fulton County records show no further action by Attorney Greenberg. On July 24, 2019, the trial court dismissed the motion for a new trial, finding that the motion for a new trial had been abandoned by defendant's failure to pursue the matter within a reasonable time. In State versus Prince Richardson, Fulton Superior Court case number 01SC05652, the charges included enticing child for indecent false imprisonment, simple battery. A motion for new trial was filed on October 25, 2001 by Carl Greenberg on the general grounds. Online, Fulton County records show no further action by Attorney Greenberg. On March 21, 2022, the state filed a motion to dismiss defendant's unresolved motion for new trial on the basis that the motion for new trial had been abandoned by the defendant. On March 22, 2022, the trial court entered an order dismissing the motion for new trial, finding that defendant had abandoned his motion. The certificate of service references State versus Darrell White, case number 06SC46211, demonstrating a failure to provide notice of the Richardson motion to the defendant. In State versus Joshua Hardiman, Fulton Superior Court case number 04SC15325, the motion for new trial was filed June 25, 2007. Online, Fulton County records list Greenberg as the attorney. Online, Fulton County records show no further action by Attorney Greenberg. On August 23, 2019, the trial court dismissed the motion for new trial, finding that the motion for new trial had been abandoned by the defendant's failure to pursue it within a reasonable time. In State versus Robert Ponder, Fulton Superior Court case number 04SC16724, defendant was sentenced on September 3, 2004. On September 29, 2004, a motion for new trial was filed. On April 14, 2005, the attorney for defendant, citing a conflict, filed a motion for appointment of substitute counsel. On June 6, 2005, Carl Greenberg entered an appearance on behalf of defendant. Online, Fulton County records show no further action by Attorney Greenberg. On July 20, 2021, defendant filed a pro se motion for appointment of counsel and motion for out-of-time appeal alleging ineffective assistance of counsel, notwithstanding the earlier filing of a motion for new trial. So again, those are related to Carl Greenberg. The first one was related to Mr. Gashard. I don't know if you want me to keep going. Anything else on the record today, or do you want to come back and talk on another day?
Well, let me see if Mr. Armstrong has anything he wants to share in connection with either of the things you just relayed.
So I was only able to look at one case really quickly. That's one where you talked about inappropriate service. The misname is, for reasons that are not real important, we include the caption, case caption above the certificate of service. That's where somebody else's name was. Prince Alexander is listed below there. And the clerk's office independently sends notices to individuals about a hearing. And it's typically when they miss a hearing, something the court ordered them to do, that a case gets dismissed for abandonment issues. And so I don't believe that's a case where somebody wasn't given appropriate notice. And I mentioned that not because it's relevant to this case, it's just because it was something that was mentioned today.
Okay. Thank you. Mr. Hort, what else did you want to talk about today?
I have just mentioned that. I thought I specifically had the certificate of service, but I don't. I can look at another day. I was just going to ask the court, I assume by the comments that the court is or will deny our motion for reconsideration.
About what I'm calling lawyer 404B.
We also had included our prayer for relief asks the court to grant the court the defendant's motion for reconsideration in order the state bar to produce names and documentation of any persons who filed grievances against Gishard and Greenberg, and to allow the defendant to present evidence of other similar acts of ineffective assistance of counsel by Gishard and Greenberg.
I wasn't sure to which you were referring. I'm just looking in Odyssey here. So in July of this year, I entered an order that will come up here about your subpoenas to the State Bar, Department of Corrections, GPC, and Pardons and Parole. That's what we're discussing here in terms of reconsidering.
That plus also our claim that under Georgia laws that then existed even now, what we're trying to point out is to other like defendants is admissible.
Okay. So I won't be reconsidering the order that I entered. I don't know that I have entered a written order as opposed to, and maybe I have, maybe it was an email saying, can we move away, please, from the attorney 404B?
I thought you did an order, but don't have everything with me today.
Okay, I'm gonna look in the docket. A lot of orders to get Mr. Alley paid. But the production orders, we've been for Waters. I don't think I've been clear in court. I just, if there was a written order, then I've tried to be clear in court, that we're not going in that space. But I don't know that I've reduced to writing the theme that we're examining as best we can Mr. Gishard's performance in Mr. Singleton's case and not how he performed in other cases. And so that's why I've excluded lines of questioning about, well, how did it go in this case or that case? You've made the proffer, that was now part of the record, but I don't know that it's in writing. It doesn't change whether you want me to reconsider it or not. I understand that.
My motion seems to suggest that there was a written order. And I know my norm, if there's such a thing, is not to do a motion for reconsideration until you get that actual written order.
Mr. Armstrong, I'm seeing in the docket just one order, and it related to the subpoenas to the different state agencies.
I certainly have a memory of you addressing it in court. I don't have a specific memory beyond the subpoena one, and looking at the subpoena one, it's not about the other criminal defendants who've been convicted and had their convictions affirmed.
Right. It may have been in an email when you were seeking guidance on which witnesses to have here, and I was trying to manage our expense account with your investigator. We don't need to track these people down because there won't be a presentation on the record, as in part of the record I'd be considering, about alleged malfeasance or underperformance or ineffective assistance in other cases, because that doesn't mean that happened in this case. So it could well have been in writing, but it would have been in an email saying, don't spend time and energy trying to get those people because you won't be able to present that.
I do remember that email exchange, and I think the state bar attorney was also part of that back and forth.
I don't know about that, but either way, that may be in an email. If you want to spend just a few minutes trying to convince me otherwise, I'm happy to listen to you. Not on the subpoenas to the state bar and pardons and paroles and GDC, but on this issue of whether I should be considering as substantive evidence, as opposed to the hearsay that I received, that Mr. Gashard was a, and I'm not speaking ill of the dead, but that he was sort of a serial underperformer. That's your theme. Because it happened there, it must have happened here. And you need to make that argument because you're shadowboxing. You can't get Mr. Gashard here to say, well, you didn't do this either, and you didn't do this, and what's your reason for doing it? And Ms. Wardell has shed some light that his reason may be, because I knew I was going to lose anyway. I don't know how compelling an answer that would be, but you don't have the luxury of that answer because he can't be here.
There are 2 points that I tried to make. First of all, he was tried in 2001, and similar acts evidence of bent of mind or course of conduct were admissible as permissible purposes for evidence of other acts under the old evidence code.
Right, but here we are in 2024.
So how does that apply? If Mr. Greenberg would have done his job and then had this all in front of Judge Downs back in 2002 or 2001, whatever.
I see what you're saying. Mr. Greenberg could have used the more expansive, back when we called them similar transactions, that theory to shoehorn into an argument that Mr. Gashard, although Mr. Gashard wasn't, I don't know that he was, I don't remember when he passed, he may well have been a witness at a timely hearing on the motion for new trial.
And my memory is, and again, you don't need to consider this as evidence, but that other appeals were able to get him to testify. I think once, even when he was relocated to Colorado, I think he testified via phone.
Yeah.
So that's my first point.
Okay.
And I cited United States versus Delgado, DELGADO, 56 F 3rd, 1357. Cert denied 516 US 1049. And then US v. Dickerson 248 F 3rd 1036 2001. But then I also cited 24-4-401, which deems evidence relevant if it has any tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence.
I think it's relevant. It's very relevant. And then there's the barrier known as 404A and 404B. It's a very expansive definition, and appropriately so, but not everything relevant comes in.
And then I cited State versus Jones, 297, Georgia 156. In 2015, the court held that the better view is that uncharged misconduct can be relevant and admissible to prove intent in both the general and specific intent cases. And that's again showing us to Mr. Gashard's intent or Mr. Greenberg. And then the relevancy of evidence of a prior state of mind and the introduction of evidence of repetitive conduct to allow a jury to draw logical inferences about a defendant's knowledge and state of mind from such conduct as well established. And extrinsic acts of evidence may be critical to the establishment of the truth as to a disputed issue, especially when that issue involves the actor's state of mind, and the only means of ascertaining that mental state is by drawing inferences from conduct. And I cited Olds, OLDS v. State, 299 Georgia 65. And then I just cited generally the due process clause and the Sixth Amendment.
Okay.
And again, I don't mean to even suggest that the court needs to tell me today how it's going to rule if it wants time.
I will take it under advisement, but I appreciate you fleshing that out a little bit more. Mr. Armstrong, you're not required to respond to that, but I want to make sure you're given that opportunity.
I do want to reiterate something that is in the state's brief, Your Honor, and that is in those cases that he cites, he is asserting them for the purpose of showing ineffective assistance of counsel. Those defendants in their own cases raised ineffective assistance of counsel and were denied. He is seeking to litigate something for which courts have evaluated claims and rejected them. It is essentially just character assassination because this person is deceased. And I don't know the basis of having these individuals testify. They're not happy, they're in prison because Mr. Bouchard handled serious cases and people go to prison for long periods of time. And so there's no basis for the admissibility for it. It's just straight propensity. It's the idea that, well, this person complained in this case, and so maybe the same complaint exists in this case.
Well, it's propensity / actions in conformity with. I mean, it's almost like habit evidence that the argument would be because Mr. Bouchard allegedly, and maybe it was even proven up, but it didn't, in the eyes of an appellate court, constitute ineffective assistance. But because he did or failed to do A, B, C, and D in all these other cases, it probably happened here. We just will never know because we can't ask him. We can triangulate because Ms. Wardell has shared some of her observations. And of course, Mr. Singleton will be able to give some firsthand observations about what did or didn't happen. But I follow your point. I guess one pushback would be someone can be acquitted of a crime and that can still be 404B because it's different burdens of proof.
Correct.
Now, it's the same burden of proof, ineffective assistance across all those cases where a court found it didn't happen and this situation. So I know we don't have the differential proof burdens, but to me, it's not dispositive of the issue that a court of appeals didn't find ineffective assistance. They may well, I think I'm going to read all these, they may well have found deficient. No lawyer should ever be that deficient, but it wasn't prejudicial. Or it was prejudicial, but the prejudice was so minor in the face of the overwhelming evidence, a la this case, that it doesn't change things.
I will note that when I looked over each of the cases that were cited in the original or the second amended motion for new trial, there was no incidence of those where it just isn't raised to this level. They were basically straight denials, either based one or the other for different reasons. I would just push back a little bit on the idea that it could be habit. I don't believe that it could be habit because habit requires a degree of unconscious thought every time that I don't think that anything similar to this could possibly raise to.
No, I agree. I'm not, that's not where I would ultimately put this, but it's just the way it's being portrayed. It's just, this is his shtick when he gets a case, in particular, if it's a case he thinks is not a winner. But habit is, there's too much thinking and decision-making involved in representing someone in a criminal trial to make it happen. The habit would be reaching for the pen right here in every trial, even though he didn't have a pen.
Yes.
That's not ineffective.
Thank you, Your Honor.
All right, thank you.
Rebuttal.
A brief rebuttal.
Habit is going to the movies instead of working on your case.
Okay.
And I would point out the cases that I mentioned today, the Lewis case, he's not in prison. He's out of prison, so that doesn't work. The other cases as to Mr. Greenberg, they never even had their appeal. They got dismissed by Superior Court judges because the defendant didn't follow through, not his attorney, defendant. So to me, that's a real difference there. I would point out, however, that we have cited other cases in our offer of proof that where the defendant has been denied their appeal, even though the appellate courts ruled against him. And that leads into my next motion that I wanted to talk to the court about. We had also filed a petition for writ of mandamus.
Okay. When did you file that? Oh, here it is. You have an amended one. Is the August one the most recent? They evolve a lot.
Yes, that is. That's the last one.
Okay.
And I know we are asking a lot, but we have two attorneys where there is at least a red flag that these attorneys were not doing their jobs as criminal attorneys. And in our petition for writ of mandamus, we are asking this court, and I would be happy as could be if even if all you did was write a letter to the Georgia Justice Project or Innocence Project, whatever, and say, hey, we'd like you to take a look at these cases. Doesn't mean you have to, but we'd like you at least to look at these cases.
Why do I need to get in the middle of that?
Because if I do it, nothing's going to happen. Mr. Armstrong's not going to do it. So if I on the petition for mandamus to look at all of these cases that have been wronged by Mr. Gishard, Mr. Greenberg, I'm not asking you to make that determination, although I kind of indirectly am. I am asking somebody somewhere to do that. And frankly, I'd be willing to volunteer to help them. I've got one case that even worse than Mr. Singleton, where the co-defendant testified or wrote the statement afterwards that he lied at the trial, that he was the shooter. And Mr. Braithwaite was not even present. And this co-defendant is now out of prison. Tony's tried to find him, no luck. But you got to
our dime in this case.
Not your case, but
well, no, I understand Braithwaite isn't involved with this case, but the county is covering Mr. Alex's very reasonable expenses. But if he is spending lots of time trying to find this co-defendant in the Braithwaite case who was released on a basis that ultimately what you're really hoping to do is have me write a letter to the Innocence Project, that seems not like an expense that ought to be attributed to representing Mr. Singleton.
Except for we're also trying to get this in under the 404B.
Okay, let's not dispatch Mr. Alec to try to find anyone else who was not a witness in the Singleton case or should have been a witness in the Singleton case.
And please feel free to deduct any amount you want from my expenses.
You owe us money.
I hope you cap mine. I hope you give me minimum wage. I don't want to have something that I have to report to the IRS that I'm now a millionaire.
Okay, so I'm now looking at the amended? Okay, the petition. So I guess you are helping me better understand it. I remember reading the petition and the amended petition when they came in. They don't actually have a prayer for relief. It's a petition, but mandamus is someone's supposed to act, you know what it is. And so I read it thinking, uh-oh, what have I not done? It wasn't me, it was Mr. Greenberg. But what you may want to do in order to get a ruling other than an order that says you have to better particularize the relief you're seeking is to better particularize the relief you're seeking. I may be missing it, but I mean, it's a classic court format, it's very dense, but it's a series of situations that you think merit attention, I guess, now that I'm understanding this. But it then doesn't say, and here's what someone has an obligation to do, and they're not.
And I certainly can. I don't know that we had this type of petition in Michigan,
Okay.
but I can add that to my research list and.
It'd be good to learn if you're gonna be filing petitions for writ of mandamus, how in Georgia they work, because there is some public actor who has a duty to act and hasn't for some reason. Judges get them often because they haven't ruled in time. And so there'll be a mandamus action filed saying, hey, you're supposed to rule within X days, you haven't, you need to do that. Not, you need to rule in a certain way. You should exercise your discretion, but it is not discretionary to issue a ruling. And so I couldn't distill from the original petition or the amended, who is the public official? What is she supposed to be doing that she didn't do? So if you want to file a second amended petition for writ of mandamus, then I might be in a position to pivot and say, Mr. Armstrong, do you, and he may not if it's what you just described, and say that state take a position on this.
I wasn't sure how amenable you would be to me petitioning you to do a writ of mandamus, ordering the judges in these other cases to re-examine or
I don't know that
reevaluate.
I'll be ordering judges to do anything.
Exactly.
That's why
what I
you need to think about what relief you want out of those. I think I get it, but it's not set forth in there, and so we ought to try to get it in right. You're welcome. Anything else?
Not today. Everything else is more tied in with when you come back.
Okay. Mr. Armstrong, anything else from the state?
None for the state, Your Honor.
No petitions for mandamus from you?
God, I wish.
Let's turn to Mr. Singleton then. Mr. Singleton, if you would unmute. Do you have any questions or issues that you need us to take up or address today?
I think I'll wait. My question might take a little longer and it might get outside the boundaries of what I'm supposed to ask and statements I'm supposed to make right now. So I'll just wait until it's my time to speak.
Okay, I respect that. You should probably connect with Mr. Hort before you share whatever it is you're contemplating sharing, because when you say it's your time to speak, just so you understand what the format will be, when we reconvene, you'll be sworn in and you'll be asked questions. So there's not going to be the open mic moment where like, and now here's what Mr. Singleton wants to riff on. That's not what's going to happen. If Mr. Hort were to ask you a question, is there anything else you want to talk about? There'll be an objection and I'll sustain that. It's not going to be tightly controlled. You and Mr. Hort know what you want to cover, but it will be about your trial and your interactions with Mr. Gashard and your interactions with Mr. Greenberg, if there were any of those. And it won't be a lot broader than that. And I share that with you. You probably already knew that. And so I'm not trying to tell you don't talk about certain things, but if you were waiting for that time when you could unload on everyone how you feel about the fact that it has taken 20+ years for your appellate rights to be pursued, trust me, I know that that's not how it's supposed to work and that you have been let down by many aspects of the system, as has Sergeant Grigley's family. They are as entitled to closure as you are. And they may well have thought that there was closure, and through no fault of theirs, this case is still rattling around. And so closure eludes those who most need it, the family and loved ones of the deceased, and the guy who's been sitting around 20 years waiting to have that day in court to which he is entitled. So I share that with you just so you know when we reconvene that it's not going to be speech time, it's going to be I'm answering questions from the lawyers.
Noted completely.
Good. Anything else?
No, sir. In line of questioning, that's the time I'm waiting on.
Okay, sounds good. Well, thank you folks at Coffee County Correctional for keeping this line of communication open all day long. I don't know if you had to not have other inmates come on in there, but this was very helpful. And we'll do this one last time sometime early in the new year.
Thank you.
All right, bye. Thank you, Mr. Hort. Mr. Armstrong.
Can I ask, with Mr. Armstrong plans on presenting any witnesses, how we're going to be able to finish in just this half a day back on wood?
That's a good question. I mean, you've entitled to call anyone and everyone who's relevant.
So the people who I would think are relevant are Sheila Ross and the investigators, there's Michael Waters' affidavits, which I do not believe to be true, come in, then I'll have to present them to basically defend themselves against an allegation made 20 years later that was never raised at the time.
Okay.
And so there's that issue, and I don't know what Mr. Singleton's going to testify to.
Okay. What seems like what we ought to do is build out a schedule that would allow us to get through Mr. Singleton's testimony. I don't think we're gonna find a full day anytime soon anyway, so let's find a half day where we can do that. And that'll also give Mr. Armstrong a chance to digest it, to say, well, you know what, based on that, I need Ms. Ross here. I'm not gonna have her wait around because you might need her. And then we would need another session for those witnesses.
Thank you. Thank you, Judge.
All right. Thank you, everyone. Thank you, Ms. Rivers.
Okay, Judge, see you tomorrow.
Tomorrow.